Good afternoon, distinguished guests, honorable speakers, and participants. Allow me to warmly welcome the Honorable Chief Justice Debra Mortimer and delegation of the Federal Court of Australia, Justice Gusti Agung Sumanatha, Chair of the Civil Chamber of the Supreme Court of Indonesia, the Chair of Indonesia Jentara School of Law, Dr. Arya Suyudi SHLLM, representative of the Australia-Indonesia Partnership for Justice 3, AIPG3, Mr. Craig Ewers, along with his team. And then our speakers for today, Reynaldo Sembiring from Indonesia Center for Environmental Law, Dr. Mas Achmad Santosa from Indonesia Ocean Justice Initiative, Dr. Wiwi Awiati from Indonesia Jentara School of Law and University of Indonesia. Last but not least, Dr. Laude M. Sharif from Australia-Indonesia Partnership for Justice Phase 3. And then our moderator, Mr. Rizky Argama, Executive Director of Indonesia Center for Law and Policy Studies, PSHK. Also greetings to participants on site at Jentera and those joining via Zoom and YouTube. My name is Agnesia Nova Kristantilaga, and I am honored to serve as your Master of Ceremony for today's international seminar. Welcome to the international seminar, Judiciaries and Climate Justice, Global Perspective on Resolving Environmental Disputes, organized by the Supreme Court of Indonesia, the Federal Court of Australia, the Indonesia Jentara School of Law, the Indonesian Center for Environmental Law, and the Indonesia Ocean Justice Initiative with support from AIPG3. To begin, I would like to invite the Chair of Indonesia Jentara School of Law, Dr. Arya Suyudi, SHLLM, to deliver the welcoming remarks. Please welcome Dr. Arya Suyudi.
Terima kasih. Thank you, Madam Moderator. Bismillahirrahmanirrahim. Good afternoon, everyone, and a very warm welcome to the international lecture, Judiciaries and Climate Justice, Global Perspective on Resolving Environmental Justice. It is true privilege to host this event in collaboration with our esteemed partners. On behalf of the Indonesia Jentara School of Law, I would like to offer special and heartfelt welcome to Honorable Chief Justice Debra Mortimer of the Federal Court of Australia. Your presence here is an immense honor for Jentara. We really deeply appreciate you making the journey. Actually, I know that it has been a very long trip for you, Chief Justice. I understand this is the third week of your mission to build international cooperation within the region and to share an Australian perspective on climate change dispute with us. Your engagement here highlights the strong commitments of the Federal Court of Australia to international cooperation and judicial dialogue on one of the most pressing legal issues of our time. And also, I would like to welcome Justice Gusti Agung Sumanatha. Thank you, Pak Agung, for making the time to visit our small campus. Finally, after this time, you visit
Recording
us.
in progress.
And also, welcome Justice Burley, Mr. Martin, and also Pak Craig, and also other distinguished resource person. Today's gathering is a testament of the strong and enduring judicial cooperation between the Supreme Court of Indonesia and Federal Court of Australia. The spirit collaboration is not new. It builds upon a long-standing tradition of knowledge exchanges and capacity building in environmental law, dating back to the Indonesia-Australia Training Project AISTP which runs from 1998 to 2002. This seminar proudly continues that vital history. We also delighted to co-organize this event with the Indonesia Center for Environmental Law, ICEL, and also Indonesia Ocean Justice Initiative, IOJI, and we are grateful for the support provided by Australia-Indonesia Partnership for Justice Phase 3. We convene at a critical time. Climate change is one of the most pressing challenges of our era. A key part of the triple planetary crisis, alongside biodiversity loss and environmental pollution. The judiciary is increasingly being called upon to play a central role in resolving complex climate disputes and advancing climate justice. Our focus today is on sharing experiences and insights on this evolving legal frontier. Both Indonesia and Australia have developed robust experience in adjudicating these complex environmental disputes. Australia ranks second globally after the United States in terms of number of climate change cases. Meanwhile, Indonesia has seen more than 20 climate-related cases filed by 2023. Indonesia, as a key global player in both land-based and marine ecosystem, faces unique challenges and opportunities in climate justice. This forum offers a crucial opportunity for Indonesian judges to gain comparative perspective on how judiciary worldwide, particularly in Australia, are adapting to address these new legal frontiers. We aim not only to promote a deeper understanding of global trend in climate litigation, but also to share best practices for managing cases involving complex scientific evidence and to encourage proactive role in upholding the rule of law in environmental matters. We are honored to have such a distinguished panel of leading legal minds from judiciary, academia, and civil society with us today. Thank you for all being here. Let us begin with important discussion. Thank you very much.
Thank you, Dr. Arya Suyudi. Next, I kindly invite Mr. Craig Ewers, representative of AIPG3, to also deliver welcoming remarks. Please welcome Mr. Craig.
Thank you for the welcome, and it's a bit of a surprise, but on behalf of AIPJ3, we're really happy to collaborate with Gentera on this event and support it and to take advantage of our esteemed visitor, Chief Justice Mortimer and Justice Burley, to be in Jakarta this week. This is, as Arya said, it's an emerging topic. There's the first cases coming through dealing with climate change, and obviously it draws on a long tradition of environmental litigation in both Indonesia and obviously in Australia. So we've got terrific speakers there. AIPJ3 will be looking at this issue as part of our scope, and this is a great way to kick it off. So we look forward to a lot more discussions. Please enjoy and participate vigorously in the questions and answers. Thank you.
Thank you very much, Mr. Craig. Now we are greatly honored to welcome Justice Gusti Agung Sumanatha, Chair of the Civil Chamber of the Supreme Court of Indonesia, to deliver the keynote speech. Your Honor, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Honorable Chief Justice Debra Mortimer, Honorable Justice Stephen Barley, and Martin, and also Greg Ewers, Chancellor of General Law School Arya Suyudi, Mas Ahmad Santosa, apakah beliau sudah hadir? Muhammad Santosa, Chief Executive Officer of the Indonesian Ocean Justice Initiative, Laude M. Sarif, Senior Advisor, Australia-Indonesia Partnership for Justice, IPJ3, Wiwi Awiyati, Lecturer at the General Law School and University of Indonesia, Rinaldo Sembiring, Executive Director of Indonesian Center for Environmental Law, Aisel Rizky Argama, Executive Director of the Indonesian Center for Law and Policy Studies, PSHK. Distinguished colleagues, fellows judges, esteemed academic, ladies and gentlemen, whom I honor, it is both an honor and a privilege for me to address you today at this important seminar, Judiciaries and Climate Justice, Global Perspective on Resolving Environmental Dispute. This event reflects our shared determination to strengthen the judiciary's role in advancing environmental and climate justice, and your presence today underscores the shared responsibility we bear in confronting the most defining challenge of our era, climate change. Let me begin with present my deepest gratitude on behalf of the Supreme Court of Indonesia to our co-organizer, STHI Jentera, the Federal Court of Australia, the Indonesian Center for Environmental Law, ICL, the Indonesian Ocean Justice Initiative, and of course with the invaluable support of the Australia-Indonesia Partnership for Justice, IPJ Phase 3. Your commitment and collaboration have made this gathering possible, creating not only a forum for dialogue but also a platform for building lasting partnership. Ladies and gentlemen, based on global trend, the judiciary's role in addressing climate change has become increasingly pronounced. Courts around the world are increasingly having to decide cases that climate change, science, policy, or law. These cases are brought to compel government and corporations to take greater action to address climate change or to remedy climate change harm that has been caused by their action or inaction. As a Honorable Justice Brian J. Preston, Chief Judge of Land and Environment Court, New South Wales, has mentioned, more judges are having to deal with scientific issues such as greenhouse gas emissions, global temperature goals, carbon budgets, causes and impact of climate change, and the adequacy of national mitigation policies and emission reduction targets. Internationally, climate-related lawsuits have surged, with a 2025 report from the Grantham Research Institute and Sabin Center for Climate Change Law identifying a total of 2,967 cases filed globally across nearly 60 countries by the end of 2024. This wave of litigation not only hold a government accountable for their climate commitment, as exemplified by the landmark Urgenda Foundation versus State of the Netherlands ruling, but also progressively target corporate entities. Within Indonesia, the Indonesian Center for Environmental Law, ICL, data note that while the majority of the country's 20-plus climate cases have historically framed climate change as a secondary concern to a broader environmental degradation. Noticeably, shift is underway. While initial lawsuit focused on illegal logging and mining, and more recent action, such as the challenge to the environmental permit for a power plant in West Java, demonstrate a strategic pivot, positioning climate impact as a central legal argument and compelling the judiciary to weigh the state obligation against the principle of intergenerational equity and the right to a healthy environment. Ladies and gentlemen, concurrently, this global judicial trend is expanding into the realm of profit and commercial litigation, which has diversified into a multi-front strategy against corporate inaction and misinformations. encompassing claim rooted in a tort law, human rights, shareholder obligation, and increasingly consumer and competition law. While Indonesia has yet to experience such development, valuable lessons can be drawn from Australia, where climate-related disputes have already tested the boundaries of corporate accountability. In several cases, shareholders and pension fund members have raised concern that companies and financial institutions fail to adequately disclose or manage climate-related risks. This proceeding, even when resolved through a settlement, have led to significant commitment such as a greater transparency in financial reporting and long-term strategies to align with net zero target. Such experiences illustrate how litigation can serve as a catalyst for enhancing corporate responsibility and improving governance on climate issues. While this judicial development are encouraging, relying solely on litigation to drive the necessary scale of corporate climate action presents significant limitation. Recent empirical research indicate that the financial impact of such lawsuit, while notably may not be transformative on its own, a comprehensive study on the impact of climate litigation found that, on average, the announcements of a case filing or an adverse court decision correspond with a modest 0.41% reduction in defendant firms' value. This litigation must be complemented by stronger legal framework and proactive judicial leadership to reshape corporate and state behavior. Ladies and gentlemen, the judiciary today carries an increasingly vital responsibility in addressing the climate crisis. Courts are not merely dispute settlers. They are guardians of justice, human rights, and the rule of law in the face of unprecedented environmental challenges. Judges are called upon to ensure that the action of state and corporations align with the principle of sustainability and the fundamental right to healthy environment. Indonesia's own judicial experience reflects this evolution. Climate litigation in our country has already contributed to the development of environmental law principles, environmental policy instrument, and ecosystem restoration framework. Many of our court decisions have explicitly invoked the precautionary principle and intergenerational justice, applying and expanding this doctrine in ways that reinforce law enforcement and environmental governance. Notably, there has been a ruling that affirmed that mitigating climate change impact is a core duty of the state to guarantee the constitutional right to a healthy environment. In this innovation, the judiciary is not only interpreting the law, but also progressively shaping its meaning and scope in the response to the climate crisis. At the same time, judges face the profound challenges of engaging the complex and contested scientific evidence, determining causality and assessing long-term impact, and balancing competing right and in interests require not only a legal reasoning but also on openness to scientific knowledge. It is in this intersection between law, science, and justice that the judiciary's leadership is most urgently needed. Distinguished ladies and gentlemen, in Indonesia, the Supreme Court has long recognized that achieving environmental and climate justice require not only a strong laws but also capable judges. To that end, the Supreme Court of the Republic of Indonesia has established an environmental judge certification system in 2011 so that the environmental cases can be handled by judges who have good knowledge, understanding, and skill. As of 2025, 1,661 judges across Indonesia have been certified as an environmental judges. This program also positions Indonesia as a model in the Asia-Pacific region, in addition to a basic environmental certification training. We have also organized several capacity building programs for environmental judges with the support of our partners, as well as judicial training and convening involving judges from across the Asia-Pacific. This demonstrates that judicial leadership can and must be institutionalized through a structured and sustained capacity building. In addition, provide clear and comprehensive guidelines for judges to adjudicate the environmental cases. The Supreme Court of the Republic of Indonesia has also complied the latest guideline for adjudicating environmental cases stipulated through Supreme Court Regulation number 1 of 2023. The Supreme Court regulation recognized that realizing climate justice is one of the objectives of judges handling environmental cases and emphasizes the importance of the recovery approach in resolving environmental law cases. Moreover, scientific evidence in a climate change litigation is highly complex. Climate cases involve vast amount of data, technical studies, and scientific projection, often spanning multiple disciplines from atmospheric science and ecology to economic and public health. Accordingly, one of the breakthroughs introduced in PERMA number 1, 2023 is that provide judges with guidance on how to access the relevancy and the credibility of scientific evidence and consider expert testimony. At the same time, it is also worth exploring the concept of concurrent expert evidence. CEE brings experts from the different disciplines together in the courtroom, allowing them to present their views concurrently and directly respond to each other's analysis. This approach transforms expert testimony from adversarial confrontation into a constructive dialogue, equipping judges with clearer and more holistic insight. With this way, the dispute narrowed the specific technical point and subsequently helped the court weigh the credibility and relevance of the expert opinion. For Indonesia, CEE could enhance the quality of judicial reasoning in complex environmental cases, particularly those involving climate change. It is an innovation that deserves a serious consideration as we continue to strengthen our procedure and ensure that justice is both scientifically sound and legal robust. From the expert standpoint, the joint examination model should be viewed as a way to enhance the accountability to expert testimony. Experts will bear greater responsibility and base their opinion strictly to their area of expertise, as many divergence among them will be directly debated before the judge, with its expert explaining the rationale behind their differing views. This process can help minimize the potential for legal action against experts. However, judges will be better positioned to elicit expert insight on unresolved or contentious issues. Consequently, it is imperative that judges develop a solid understanding of the complex environmental challenges at hand. None of this aspiration can be achieved in isolation. Judicial leadership in climate justice require robust international cooperation. Our partnership with Australia exemplifies this. Historically, Indonesia and Australia have nurtured strong collaborations in strengthening judicial capacity on environmental law since the Indonesian-Australia Training Project (ISTP) between 1998 and 2002, implemented by the Supreme Court of Indonesia, ISEL, Center for Environmental Law of the Sydney University and the University of South Australia. That initiative laid the foundation for the trust and cooperation that we continue to build today. Now, through IPG Phase 3, our collaboration extends even further, involving not only the court, but also civil society, academic, and practitioners. The spirit of partnership illustrates that climate justice is not the responsibility of a single nation or institution. It is a shared global endeavor requiring solidarity and leadership across borders. Distinguished guests, ladies and gentlemen, the judiciary's role in advancing climate justice is both profound and urgent. We are not merely arbiters of a dispute. We are custodians of justice, protectors of human rights, and guardians of the future. In our hand lays the responsibility to ensure that law responds to the greatest challenge of our time, the climate crisis. Through innovations such as environmental judge certification, procedural reform, and international partnership, that span decades, the Supreme Court of Indonesia is committed to strengthening its capacity and leadership in this endeavor. I firmly believe that together, judges, academic practitioners, civil society, and the business community, we can build a judiciary that not only resolve dispute but also inspire action, uphold justice, and safeguard the planet for generations to come. Let this seminar be a reminder of our shared responsibility, and let it be a springboard for even greater cooperation in the pursuit of climate justice. Thank you very much.
Thank you, Your Honor, for the inspiring keynote. Before we continuing, may I invite everyone to join the first group photo sessions, which will be guided by our photographer. Please stand up to photo. Okay, thank you very much. It is now my honor to welcome the Honorable Chief Justice Debra Mortimer of the Federal Court of Australia to deliver the International Lecture on Trends in Climate Change Disputes. Your Excellency, the floor is
Salam alaikum and good afternoon. So climate change is a controversial subject, and it's very controversial for judges in particular in Australia and in our friends across the Tasman in New Zealand because of the historical emphasis on the separation of the courts from the executive and from Parliament. And those are very strong principles in our legal system, and they work in very different ways. But in this kind of area, in an area that's politically charged, courts can be criticised for intruding into things that are really the domain of politicians. And that is something that courts in Australia have had, and New Zealand have had to grapple with. It's about the effects of global warming, and a little bit of a summary about what has succeeded and what has not, and a little bit about perhaps why. And then secondly, I'm going to talk very briefly, but very importantly, about what I call strategic litigation, because all these cases have come about because of strategic litigation, and I want to say something about that. That is partly driven because before I became a judge, I was a strategic litigator, and I did a lot of work in the environment area in particular. So I understand the importance of that. Now, I also want to start by, where do I point the clicker to make it go? There we go. It's okay. Got it. So, many of you will know about Eddie Koiki Mabo, Torres Strait Islander, who was responsible for bringing a case about traditional ownership of land in Australia that produced a revolution in Australian law in several ways. But the way that I want to talk about today and why this is relevant to litigation about global warming and climate change is that the lead judgment in the Mabo case, which was delivered by Justice Brennan, a judge of the High Court for whom I clerked as an associate, recognised that the common law, our common law tradition, is not stagnant, is not static. And there are, hang on, this is not, there we go. I'll share the PowerPoint later and you can read these quotes in detail. But the basic point that Justice Brennan was making in this case was that the law needs to move and it needs to develop. It must do so according to fundamental principles that don't upset your legal system as it is. But His Honour recognised that the law must change. And that is something that's very important for how courts are going to deal with climate change cases. So I'm just going to skip through these. So the first, and on to the category of cases. So first category of cases that we often see, particularly in the federal court, are what we call judicial review cases. And they are cases, judicial review is a kind of proceeding that is supervising government decision making, supervising it for lawfulness. Now, we have a lot of these cases, and I've put up there a slide about one brought by a group of Tiwi Islanders. The Tiwi Islands are in the north of Australia, about the development of a pipeline by Santosa. These cases are very difficult to win, and that is because they depend on looking at the powers that have been given to the government decision makers and only assessing whether those powers have been lawfully exercised. So you can't really argue about the outcome and whether it's right or wrong. You can only argue about whether the decision maker stayed within their power. So they're very difficult to win. And you can see the consequences there, that we operate in a jurisdiction where the loser can be forced to pay the costs, the legal costs of the winner. And that is a disincentive for environmental groups or Indigenous groups, because sometimes they can really be bankrupted because of the costs. So there's a lot of judicial review cases, but not many of them succeed. Another category are challenges by Indigenous groups under our native title legislation. So once Indigenous groups have their native title recognised, they have some rights under the legislation to be consulted about developments on their land. So the Gomeroi case was a case where the Gomeroi people wanted to object to a coal mine that was proposed to be built on their land. But they don't have a power of veto. But they wanted to say that the tribunal that was making the approval decision needed to think about the effects of climate change on them as traditional owners. And our court, I was a member of that court, we upheld the fact that the tribunal had to look at that issue because it hadn't looked at it, it had put it to one side. So the case went back to the tribunal for it to do the job again, but the Gomeroi people did not win. So this time, this is another limitation. The tribunal did its job again, the court does not control the outcome, and again the Gomeroi people lost in their objection to the coal mine going ahead. Another common form of environmental litigation is about native forest logging, and I heard His Honour talk a little bit about that. So this is an area that has become much more successful in litigation in Australia. And it's a very good example of strategic litigation with environmental groups, often community groups, working very hard to get very good evidence about the effects of logging, particularly on some of Australia's threatened species. And of course, why has this got anything to do with climate change? Because it protects our native forests, which are carbon sinks, and it stops extra deforestation. So this kind of litigation, going back again to something that Justice Agung talked about, involves a lot of expert evidence because you have to prove the effects of the logging on the species that are living in the forest. So a lot of expert evidence needed. But this kind of litigation has been quite successful. And now one case builds on another case, and the lawyers and the environmental groups that are working in this area look at what succeeded in the previous case, what kinds of arguments succeeded, what sort of evidence they needed, and they build from case to case. So much so that in Victoria, where this case come from, we had so many cases that succeeded about logging of our native forest that our government in Victoria stopped logging native forest because the evidence was so strong about the damage it was doing, and the political consequences of losing all these cases meant that the community did not support native forest logging anymore. So the story is not always bad. This is a very recent case, also coming out of our court. It's called Pabai Pabai, again brought by a Torres Strait Islander. Torres Strait Islander people are very dedicated to their environment and to protecting it. And Pabai Pabai brought a representative proceeding, a class action on behalf of Torres Strait Islanders against the Australian government, saying that the way that the Australian government was failing to take action on global warming meant that for Torres Strait Islanders, they were losing their islands. So the Torres Strait Islands, like Tuvalu and a lot of these other Pacific Island nations, are very low-lying. And so the evidence in this case included things like the islanders were losing the graveyards of their elders. They were being washed away into the sea. So these people had some very powerful evidence about the effects of global warming on them, on their traditional lifestyle. And the judge that heard the case, a colleague of Justice Burley's and mine, was very sympathetic to that. And he made a lot of factual findings, saying, yes, the Australian government had not applied best available science. That is true. Yes, there was a lot of damage. He agreed factually with a lot of the case. And then he came to the law, and he found that there was no legal solution for these people, and that the government did not owe them in the law a duty of care, which is what they were arguing. He found that the existing law in Australia, which bound him as a single judge, was so strong, so one way, that he could not make any other decision. And he made some comments about it, saying that there was really nothing that he could do as one judge, bound by other decisions, and the law needed to be changed, either by a higher court or by the Parliament. And you will see the last thing that he says there, that the solution might be at the ballot box, not with the courts. So, but this decision is likely to go on appeal. So it will go on appeal first to 3 judges in our court, and whatever the outcome, it will probably go to our High Court after that. So this is still in progress, But it's an example of how difficult in Australia the actual content of the law is for judges to deal with, even if the facts are very clear. Now, this is another ongoing case, not in Australia but in New Zealand. You have to forgive me because I'm originally from New Zealand, so I got to put a case in about New Zealand. This is a fantastic case, and if you don't know about it, I urge you to follow it. It's going on right now. It's a case about the law of nuisance, apart from anything else. It's brought by a Maori man against Fonterra, which is one of the largest dairy producers in New Zealand. And you can see, pardon me, I can't see, but yes. So you can see that Fonterra operates a large number of dairy farms, big, high commercial value dairy farms. It operates power stations, coal-fired power stations, to process the milk. It's a large emitter of greenhouse gas emissions. So this Maori man who owns land in the north of New Zealand has brought a case about the effects of greenhouse gas emissions on his tribe, on his way of life, on his tribe's way of life. And when this started in the courts, the New Zealand courts said that it was hopeless. And it was so hopeless that they were going to strike it out. Now, I don't know if that's a process here, but in our system, strike out means a case is so hopeless you don't even have to send it to trial. You can just get rid of it. So that's what happened to this case. But then when, and this was his argument, so he uses a very old tort from English common law called nuisance, which was originally about things like if you have a factory and the sewerage escapes into a river, then people who live downstream from the river can claim damage. Now, he and his lawyers are turning this tort to a modern use for climate change. And if you read the decision, it's very, very interesting about how they're doing that. Now, as I say, the lower courts thought it was hopeless. Sorry. That's what the lower courts found. They said, nothing to do with the courts. It's too hopeless. Climate change is too big a problem. You can't bring a private proceeding like this. But he goes up to the New Zealand Supreme Court, which is their ultimate court. And this is very recent, and the New Zealand Supreme Court has said no, he should be allowed to run his case through to trial. So they have said this is complicated, going back to these issues about the evidence, and you have to look at it in the whole context. And they're saying, don't just say it's hopeless, let him run the whole case, let him develop it with his expert evidence and everything else. And so they have sent it back to the lower courts. And so that case will continue on, and I urge you to watch it. I think it's going to be a very interesting case. So another area is in Australia that has had a little bit of success are planning cases. Now that's because in our systems with a planning case, you're making a decision about what the actual outcome should be. You're not just arguing about whether it's lawful or not. And in this case, there was a proposal to develop a coal mine in Queensland, and the Queensland Land Court looked at the objections that were put in by Indigenous people, by community groups. They looked at human rights arguments. They looked at global warming arguments, they looked at a lot of science, and they upheld the objections. and they recommended to the Queensland government that the coal mine not be approved. That is a massive decision, and it was not appealed. So that decision stood. There's the citation, you can read it. And as far as I know, the Queensland government accepted that recommendation, and that coal mine is not going ahead. So that was a massive win for the community groups that brought that case. A lot of lawyers put a lot of time, of volunteer time, into running that case. And they were lucky it was not appealed, I think. Oh. That one. Yeah. Is it easier if I just say next slide? Okay, I'll just say next slide. This was an unsuccessful case. Another ambitious case brought by this young woman, Ms. Sharma, in our court, in the federal court. She claimed that the government, when it was making a decision whether or not to approve a coal mine, owed a duty of care to all children, because they were the people who were going to inherit Australia and inherit an environment, and that the government had a duty to take that into account when it was making a decision about whether to approve a coal mine and not to approve the coal mine, really was where she was going. It was a very ambitious case, and again, our courts said that the law did not recognise that kind of duty of care. And part of the reason they gave for that was that these were policy issues, political issues. They were not for the judiciary, they were for the government. And that was an unsuccessful case, but a very ambitious one. Next slide, please. Greenwashing. So this is an area that's becoming quite a common area in our court. Our court has a jurisdiction for regulating consumer protection and the actions of corporations. And in Australia, we have a corporate regulator called the ACCC that looks at the behaviour of corporations, particularly in relation to consumers. And so greenwashing is the practice of making misleading public representations about how environmentally friendly products are. And so our corporate regulator is watching what various corporations are doing in their advertising and how they are selling their products. So we recently had a case, one of our colleagues had a case about a representation on the packaging of rubbish bags, you know, the sort you put in your garbage, that said 50% ocean plastic recycled on the label. And the corporate regulator said, that's not true. And they ran a case about that, and they proved that that representation was not true. And one of our judges fined that corporation 8.25 million Australian dollars for that contravention. Another case, this one has not finished yet, next slide please, is this one, again brought by our corporate regulator. The gas companies brought this advertising campaign trying to get people to switch to using natural gas. And the corporate regulator says that they have misled the consumers, because if you look at this ad and the ad that went with it, which had sort of lots of children skipping around, next slide, and said these sorts of things in the advertisement. It made it seem like the gas was going to be of a renewable kind, hydrogen or biomethane or something like that. And it made it look like the consumers, if they signed up to get a gas account, they would be using that renewable gas straight away. And the ACCC says that's not true. That's a long way in the future. And that is not what consumers would get if they signed up. So this case is still going in our court, but it's a good example of greenwashing, and it's a good example of the Australian authorities, corporate regulatory authorities, keeping a close eye on what corporations are saying in their advertising. Next slide, please. So this is another area where climate change is having an effect, also not yet in cases in our court, but they will come. How can people from countries like Tuvalu, what can they do if they can't stay on their islands anymore? Should they be protected under international conventions like the Refugees Convention? Do we need to modify the Refugees Convention so that it covers climate refugees? But you will see in some of the quotes here that the Tuvalans are saying, well, we don't want that. We want you to fix the problem of global warming so we can stay on our islands because we don't want to leave them. One of the things that Australia has done recently is offer a new visa category to people from Tuvalu so that they can leave and come to Australia. But a lot of people in Tuvalu are saying that's not the right solution. We don't want to be we don't want to volunteer to be refugees. We want to stay on our lands. All right, so I think you can see from that there are some kinds of cases that are successful, there are some kinds of cases that are unsuccessful because of the difficulties with the law itself. And if you think back to what I said about the Mabo case, we need to think about how you can change and develop the law in a principled way so that we can accommodate some of the challenges that our countries are now facing. And that's why I want to finish by saying a little bit about strategic litigation. Next slide, please. So I don't know if any of you know about this case. It's a very famous English case, English common law case from 1928, where a new kind of personal injury case was created by the creation of the tort of negligence in the United Kingdom House of Lords, where a woman who had drunk some ginger beer that had a snail in it suffered some damage, and at the time the law said she couldn't sue the people that manufactured the ginger beer. They were too far away in the consumer chain. But the House of Lords said no, and they asked, who is really your neighbour? Who do you have to take care not to injure? And so started a very important part of the common law in countries like Australia, the law of negligence, which a lot of these other climate change cases are now relying on. And I'm just pointing out that to emphasise again, just like the Mabo case, that judges can develop the law. It's a matter of how they do it, what principles they use. Which brings me to strategic litigation. Next slide, please. So that's a case, a quote from Fonterra. So the New Zealand Supreme Court is clearly sending a message there that judges can develop the law. And we'll see what the lower courts say about that. Next slide, please. But if you're thinking about strategic litigation, then I think these are the three questions you have to ask. Any groups that are litigating and lawyers that are helping them need to ask these cases. Have you got good facts? Is it a good factual case? Have you got good expert evidence to support what you're going to say? Second question, are you being too ambitious in what you're asking the court to do? So certainly in our system, the law develops step by step by step, little step by little step. If you jump too much to a very big argument, perhaps like the argument that the children made about being owed a duty of care, the judges tend to say, oh, that's a very big step. And so sometimes you can be a bit too ambitious if you're launching strategic litigation. The better question, I think, is to ask, are you building on the existing law? Are you taking a building block and then developing it only a little bit, and then you're only asking the court to take a small step? And those are generally the cases that have been more successful, where only a small step that fits within existing principle and is just a small advancement. They are the kind of cases that generally tend to be more successful. And this is an area when you're dealing with strategic litigation where you have to be careful not to make bad law. So when you bring a case, a test case, a public interest case, you can make good law, but you can also make bad law, and then that law is there. So that's why people that are litigating, I think, have to be very careful about what they choose to litigate about. I finished with that about strategic litigation because the basic proposition is that as judges, we can only decide the cases that are brought to us. And so we depend on dedicated lawyers with clients who are prepared to be brave and courageous to bring the cases to the judges so that they can decide them. And in that sense, we each perform our functions in the legal system and we work together. Thank you very much.
Thank you very much, Your Excellency, for the enlightening presentation. We now move to our panel discussion under the theme Building Climate Responsive Judiciaries. This session will be moderated by Mr. Rizky Argama, the Executive Director of Indonesia Center for Law and Policy Studies PSHK and Head of Fundamental Legal Studies, Indonesia Jentera School of Law. His expertise includes constitutional law, regulatory reform, freedom of association, non-profit law, and tobacco control policy. Mr. Argama, the floor is yours.
Thank you very much. Good afternoon, everyone. And thank you so much, Chief Justice Mortimer, for your insightful lecture. We'll now continue with the response session, so the panelist session. I would like to invite again Chief Justice Mortimer, together with our 4 discussants, to please come forward and take their seats at the front. So allow me to briefly introduce our discussant today. We'll join Chief Justice Mortimer. The first discussant will be Bapak Reynaldo Sembiring, or Bang Dodo, Executive Director of the Indonesian Center for Environmental Law. Please, Bang Dodo. Our second discussion will be Pak Dr. Mas Achmad Santosa, or Pak Ota, CEO of the Indonesian Ocean Justice Initiative, or IOJI. Silakan Pak Ota. The next discussion will be Ibu Dr. Wiwi Awiyati, faculty member of Indonesia Jentera School of Law and the Faculty of Law, Universitas Indonesia. And last but not least, Bapak Dr. Laude M. Sharif, Senior Advisor, Australia-Indonesia Partnership for Justice Phase 3. Silakan Pak Laude. Oh, okay, he's still out. Yeah, and also we also invite again Chief Justice Mortimer to sit in front, maybe in the center. Mungkin Mbak Wiwi di sini. Okay, we will waiting for Pak Laude, and the discussion will be in Indonesian and English actually. So some of our discussions will be use English, and also some of them will also use Indonesian. And for those who want to ask or give some response in Indonesian, it's okay because we have some device for interpretation today. Okay, maybe we can start. Each of the discussants will respond the Chief Justice Mortimer's lecture from their own field, and after that, we will open the floor for questions and discussion with all panelists. And note for all the discussants, each of response will have 10 minutes to share their perspectives. So me as moderator will remind each of the discussant if the time is over. So let me to remind all of you. So the first one, I will invite Bang Dodo, Reynaldo Sembiring, to share his perspective about the emerging trends of climate-related disputes in Indonesian courts. Your time is 10 minutes. Bang Dodo, please. Silakan Pak Laude. Silakan Bang.
I'm almost go to the court directly.
Oh ya, silakan.
Yeah, thank you Mas Gama. Mas Gama already mentioned that the discussion will explain in Bahasa and in English. So please allow me to explain my presentation in Bahasa, but I already made all of the slides in English. Oke, saya akan mulai. Oke, pertama-tama saya mungkin mohon maaf, ini gimana ya? Oke, pertama-tama saya mungkin mohon maaf karena bisa jadi tidak merespon secara langsung apa yang disampaikan oleh Chief Justice Debra tadi, karena juga tadi saya baru baca gitu ya, baru lihat presentasinya begitu. Tapi kira-kira mungkin ini ada sedikit konteks dari Indonesia, mungkin kita bisa pelajarin untuk kita lihat bagaimana sebenarnya pembelajaran Indonesia ini juga satu pembelajaran yang diambil dari pembelajaran secara global. Secara umum sebenarnya kalau kita bisa bilang ada dua stream untuk mengklasifikasikan apakah sebuah kasus itu dikategorikan sebagai kasus iklim, climate litigation atau bukan gitu. Stream pertama atau kelompok pertama itu adalah grupnya Sebin, Grantham, dan UNEP yang akhirnya menggunakan sangat-sangat fokus bahwa climate litigation itu sesuatu yang bicara soal adaptation, soal mitigation, soal loss and damage, dan soal penurunan emisi gas rumah kaca gitu, tidak melampaui 1,5. Grup kedua sebenarnya ada dari pemikirannya Pilenosovsky yang sejak 2015 sudah bilang kalau tidak semua climate litigation itu sebenarnya adalah litigasi yang sejak awal diniatkan untuk mempunyai argumentasi perubahan iklim yang kuat, kira-kira begitu. Nah, untuk presentasi ini untuk memudahkan kita membaca bagaimana konteks di Indonesia, saya akan menggunakan yang kedua, yang menggunakan Pilenosovsky dengan alasan bahwa ini yang paling cocok sebenarnya dengan situasi yang ada di Indonesia. Saya coba lanjut. Mana ya? Oke. Jadi kira-kira climate change cases Indonesia itu secara angka, kalau kita lihat menggunakan Osovsky tadi, jadi Osovsky itu bilang kira-kira begini, mohon maaf ya tadi saya lupa ininya. Aduh, gimana ya? Kok jadi maju? Mundur. Oke. Kan kalau tadi kita lihat dari Joanna Setzer yang merupakan representatif dari Grantham, dari UNEP, dari Sebin, mereka sangat strict bahwa ya argumentasi utamanya harus argumentasi perubahan iklim. Tapi kalau Pilenosovsky itu bilang ada 4 tier gitu. Tier pertama adalah litigation dengan climate change sebagai isu utamanya. Yang tier yang kedua peripheral, yang ketiga motivasi, yang ketiga, yang keempat itu terkait, kira-kira begitu. Jadi empat-empatnya bisa dikategorikan sebagai litigasi perubahan iklim, walaupun secara kualitas pasti lebih berkualitas yang pertama dibandingkan yang ke tier kedua, tier ketiga, tier keempat. Apa bedanya saya akan sampaikan berikut ini di konteks Indonesia. Ada 20 kasus kalau pakai kategori atau metode dari Pilenosovsky tadi. Kira-kira dari 20 kasus ini sejak tahun 2009 dan kami hitung di AISA sampai dengan tahun 2023 terakhir begitu. Yang mana dari 20 kasus yang ada di pengadilan ini sayangnya cuma ada satu yang ada di first tier, di tier atau kelompok pertama. Jadi kita cuma punya satu kasus di pengadilan yang memang menggunakan climate argument itu sebagai argumentasi utamanya dalam dalil gitu atau dalam klaimnya. Sisanya mayoritas adalah di periferal dan sedikit ada di motivasi dan sedikit ada di isu-isu yang keempat, kira-kira begitu. Saya coba lanjut. Nah, ini kira-kira ada kasusnya, saya pikir saya nggak akan sampaikan satu-satu, tetapi kasus yang tadi saya bilang ada di first circle atau the first tier itu adalah kasusnya Walhi yang menggugat pemerintah Provinsi Jawa Barat untuk membatalkan izin lingkungan PLTU Tanjung Jati A. Dan ini kasus pertama juga yang mana izin lingkungannya PLTU itu dibatalkan. Kita mungkin punya beberapa kasus terkait dengan sektor hutan berbasis lahan, tetapi untuk yang energi ini kasus pertama. Dan yang kedua, dan ini mungkin kasus yang cukup menggemparkan ya, karena pada saat itu kita berapa kali tuh melihat bahwa banyak kasus-kasus climate litigation menggugat PLTU itu bisa dibilang belum berhasil di beberapa kasus. Tapi yang kedua itu mungkin yang menggunakan jurisdiksi lain yang ada di first tier, itu bisa dilihat itu adalah gugatan yang cukup terkenal sekarang, masyarakat Pulau Pari yang menggugat perusahaan Holcim yang ada di Swiss yang menggunakan jurisdiksi lain atas kontribusi kenaikan permukaan air laut ya dari Holcim kepada 4 masyarakat Pulau Pari. Adalah ada beberapa orang muda yang mengajukan semacam petisi kepada Komnas HAM. Nah, ini juga kategorikan sebagai climate litigation tapi yang di luar proses climate cases tapi yang di luar pra-peradilan. Kira-kira begitu. Nah, lanjut. Ini kecepatan. Mundur aja deh. Ini ada yang operasiin ya? Mundur. Oh, diomongin aja. Oke. Kebanyakan yang menariknya coba lanjut. Lanjut. Nah, ini yang menariknya sebenarnya. Hal yang menarik dari climate litigation di Indonesia, dan saya tahu ini bukan berdasarkan satu pemikiran yang matang, tetapi hasil dari ketidaksengajaan, bahwa 60% dari climate litigation di Indonesia itu penggugatnya adalah pemerintah. Sesuatu yang cukup, mungkin pertama disayangkan, yang kedua aneh gitu. Anehnya kenapa? Anehnya karena memang mereka mempunyai hak gugat di bawah undang-undang lingkungan. Dan mayoritas kasus-kasusnya ada sekitar 11-12 kasus di mana mereka menggugat perusahaan pembakar hutan dan lahan. Kenapa akhirnya pemerintah Indonesia di bawah Menteri Lingkungan Hidup dikategorikan sebagai plaintiff dalam climate litigation? Itu karena dalam pembuktiannya, dalam pembuktian atas kerugian lingkungan yang terjadi, dia membuktikan valuasi atau menghitung valuasi dan membuktikan seberapa besar CO2 yang lepas dan dampaknya terhadap atmosfer. Kira-kira begitu. Hanya karena itu. Tetapi kalau kita lihat sebenarnya valuasi atas CO2 yang lepas itu sebenarnya ada satu mandat yang ada di peraturan pelaksananya. Jadi kalau kita baca pasal 90 Undang-Undang Lingkungan itu kira-kira bilang instansi pemerintah pusat dan pemerintah daerah dapat mengajukan gugatan kepada perusahaan kira-kira gitu akibat terjadi kerugian lingkungan. Nah, untuk membuktikan kerugian lingkungan dibutuhkan ada sebuah valuasi. Di dalam peraturan pelaksananya, salah satu metode dalam valuasi adalah harus menghitung berapa besar CO2 yang lepas. Kira-kira begitu. Dan sering sekali itu dipakai gitu ya, kasus karena di kebakaran hutan pasti akan ada tuh CO2 yang lepas atau illegal logging. Nah, karena itu ada di dalam dalilnya, mau tidak mau dikategorikan sebagai kasus-kasus perubahan iklim yang itu bisa bikin. Dan ini bukan klaim dari ISEL, bukan klaim dari saya. Kita uji misalnya di reportnya UNEP, keluar. Uji di reportnya Sabin, keluar. Uji di reportnya Grantham, keluar begitu. Jadi ini sesuatu yang mungkin secara ketidaksengajaan, padahal niatnya tidak ke sana, hanya meminta ganti rugi lingkungan, tetapi akhirnya bisa dikategorikan sebagai gugatan perubahan iklim. Di sisi lain sebenarnya, kalau kita lihat, ada beberapa gugatan, seperti gugatan di tier 3 tadi itu, masyarakat di Samarinda menggugat pemerintah atas kelalaiannya, atas tidak mengkontrol izin pertambangan, yang kemudian atas kelalaian itu terjadi dampak perubahan iklim, seperti banjir dan seterusnya. Niatnya sejak awal adalah gugatan perubahan iklim. Saya ingat tuh, karena dalam beberapa kali persidangan itu terrecord bahwa mereka bilang ini adalah gugatan perubahan iklim karena ketika tambang itu dikeruk, ada metan yang lepas dan itu menghasilkan CO2 ekuivalen, kira-kira begitu. berdampak buruk kepada atmosfer. Tapi sayangnya dalam konstruksi gugatannya tidak keluar argumentasi perubahan iklimnya, sehingga dia masuknya kepada tier 3. Oleh karena itulah ketika kita mendefinisikan kasus perubahan iklim di Indonesia, memang tidak bisa strict gitu ya, menggunakan metode yang digunakan tadi oleh kelompoknya Sabin, kira-kira begitu. Columbia maksudnya, Sabin and Grantham, tidak bisa strict seperti itu karena memang ada kasus-kasus yang memang tidak disengajakan, bisa dikategorikan sebagai kasus perubahan iklim, ada kasus yang diniatkan sebagai gugatan perubahan iklim tetapi sebenarnya tidak tidak bisa kena gitu karena argumentasinya tidak muncul sebagai argumentasi utama.
You have 2 minutes.
Oke, saya lanjut aja sedikit. Lanjut. Nah, jadi ini 62% dari penggugat, mohon maaf ya saya bingung pakai ini. Ini adalah pemerintah, di sini masyarakat sipil, masyarakat, di sini permit, ini penggugatnya organisasi lingkungan, di sini citizen dan organisasi lingkungan. Jadi kira-kira begitu komposisinya. Lanjut aja. Bagaimana impact ya? Lanjut, ini sedikit saja. Yang menarik dari kasus Tanjung Jati A adalah sebenarnya ada perubahan prinsip yang menarik. Jadi kira-kira begini, pengadilan itu mengatakan bahwa penerbitan izin lingkungan PLTU Tanjung Jati A itu melanggar asas kecermatan. Dan asas kecermatan itu dipersamakan dengan asas kehati-hatian. Sehingga asas kecermatan itu yang merupakan AUPB akhirnya bisa mengambil asas kehati-hatian sebagai AUPB. Kira-kira begitu. Asas ini melanggar asas kehati-hatian yang merupakan juga asas kecermatan, sehingga asas kehati-hatian per kasus ini karena sudah final dan binding bisa dikategorikan sebagai AUPB. Akhirnya kira-kira begitu ya, asas kehati-hatian. Ini kira-kira kasus yang menarik. Yang kedua, dari kasus Tanjung Jati A ini, untuk pertama kalinya ada pembatalan izin yang berdasarkan argumentasi ilmiah. Karena izin lingkungan ini dibatalkan dalam argumentasi hakim mengatakan bahwa berdasarkan data yang disampaikan oleh penggugat dalam argumentasinya akan ada sekitar 2 juta ton CO2 ekuivalen yang akan lepas. Kira-kira begitu. Sehingga karena ini angkanya sangat besar, maka tidak boleh izin lingkungan ini diterbitkan atau harus dibatalkan. Karena operasi bisa menghasilkan sebuah dampak perubahan iklim yang luar biasa. Saya boleh mundur sedikit aja. Mundur, waktu saya terbatas. Lanjut, mundur sedikit aja Mas Gama. Ini di sini. Kenapa akhirnya kita harus membicarakan ini? Kira-kira ini akan pokoknya kan kira-kira. Pertama, artikel 2 dari Paris Agreement sudah bilang kita nggak boleh lebih dari 1,5 derajat. Kalau nggak kita akan punah, itu udah clear. Kemudian Sekretariat UNFCCC sudah bilang itu sebenarnya negara-negara ini sudah ngabisin anggaran karbon 89% sampai dengan tahun 2030. Jadi karbon budget yang tersisa itu tinggal sedikit lagi sisanya gitu. Dan itu berbahaya. Dan UNEP, nggak cuma UNEP ya, tapi juga dari WMO, Badan Meteorologi, mengatakan bahwa di akhir abad ini kita akan sampai kepada 2,8 derajat Celcius kalau masih kayak begini-begini aja. Nah, terus sekarang yang 2 hal yang terakhir ini menunjukkan catatan yang agak menarik begitu. IPCC memprediksi bahwa legal instrument bisa mereduce emisi itu sampai dengan 5,9 gigaton CO2 equivalent compare to 2016. Ini kalau salah report 2022 atau 2023. Dan yang terakhir per 2016, berarti per 10 tahun yang lalu, instrumen hukum itu sudah bisa mencegah rilisnya CO2 equivalent itu sekitar 37,7 gigaton CO2 equivalent. Jadi ini adalah alasan kenapa kita butuh climate litigation, itu tadi, dan kenapa kita juga butuh climate justice bill sebagai dasar hukumnya. Itu dari saya, terima kasih. Mohon maaf jika ada hal yang terburu-buru. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Bang Dodo. Thank you. Yeah, it's 10 minutes past 2 minutes, Bang Dodo. Thank you so much. And I think the main point is the last one, which is about the urgency of climate justice bill and climate litigation. Thank you, Bang Dodo. And the next one, I will invite Pak Ota, Dr. Mas Achmad Santosa, to share more about how the judges deal with disputes involving fisheries or coastal impacts, and how should they integrate evolving international commitments like the Paris Agreement together with complex climate science. Please, Pak Ota.
Terima kasih moderator. Assalamualaikum warahmatullahi wabarakatuh. Selamat sore, salam sejahtera buat untuk kita semua. Om Shanti Shanti, Om Shalom. Our special guest yang mulia Chief Justice Debra Mortimer, dan para delegasi dari Australia, yang terhormat yang mulia I Gusti Agung Sumanatha, Bapak dan Ibu panelis dan seluruh peserta seminar dan pimpinan dari Sekolah Tinggi Ilmu Hukum Jentera. Tahun 2024 tercatat sebagai tahun terpanas dalam sejarah dengan suhu global meningkat 1,55 derajat Celcius di atas rata-rata praindustri. Rekor tertinggi selama 175 tahun, ini berdasarkan WMO 2025. Laporan IPCC tahun 2023 menegaskan dampak perubahan iklim telah nyata dan dalam beberapa kasus bersifat irreversible. Gelombang panas makin sering terjadi, banjir dan kekeringan makin parah, serta ekosistem darat, pesisir, dan laut mengalami degradasi. Sangat jelas, the first global stocktake sebagai mandat dari Paris Agreement yang diluncurkan pada COP28 UNFCCC di Dubai tahun 2023 memberi peringatan nyata. Aksi mitigasi global masih jauh dari target yang disepakati dunia. Untuk menjaga suhu di bawah 2 derajat Celcius, masih ada kesenjangan defisit 16 gigaton CO2 ekuivalen. Pada tahun 2020, untuk target 1,5 derajat yang disepakati dalam Paris Agreement, kesenjangannya tentu lebih besar, 24 gigaton CO2 ekuivalen. Angka ini menunjukkan, meskipun semua komitmen iklim yang terhimpun dalam NDC negara-negara seluruh dunia dan dilaksanakan secara penuh, dunia masih berada di jalur yang berbahaya atau off track. Karena itu, second NDC yang akan disampaikan pada COP30 di Belém, Brazil beberapa minggu yang akan datang akan menjadi momen penentu dengan asumsi setiap negara berani merumuskan target yang jauh lebih ambisius dibandingkan sebelumnya. Indonesia, rumah kita sendiri, berada di posisi 163 dari 180 negara dalam Environmental Performance Index versi Yale University. Dalam satu kelompok dengan Liberia, Rwanda, Burundi, dan Nepal. Peringkat ini mencerminkan kelemahan serius dalam 3 hal mendasar. Kesehatan lingkungan, vitalitas ekosistem, dan kemampuan kita dalam menghadapi perubahan iklim. Pertanyaannya, apakah kerangka hukum lingkungan internasional dan nasional mampu merespon triple planetary crisis, krisis iklim, hilangnya keanekaragaman hayati, dan polusi yang disebabkan oleh tekanan antropogenik. Kerangka hukum lingkungan saat ini masih berorientasi pada anthropocentrism, menempatkan manusia sebagai center of concerns, sementara alam diperlakukan sebagai objek. Prinsip ini berakar dari Deklarasi Stockholm 72, Deklarasi Rio 1992 yang menekankan human primacy, bukan ecological primacy. Padahal keberlanjutan ekosistem membutuhkan pengakuan integritas ekologis dan interdependensi manusia dan alam, human being dan other living being. Dalam sejarah kebijakan lingkungan Indonesia, kita pernah memiliki modal awal, yaitu pengakuan beyond anthropocentrism, antara lain pengakuan dalam Undang-Undang PPLH, Perlindungan dan Pengelolaan Lingkungan Hidup, bahwa perlindungan lingkungan penting bagi kelangsungan hidup manusia dan makhluk lain. Namun ketidakselarasan dan kebijakan sektoral dan kebijakan pembangunan ekonomi kita justru menegaskan beyond anthropocentrism ini. Bukan menegaskan, menegasikan modal beyond anthropocentrism ini, yaitu mengucilkan makna dari perlunya menjaga daya dukung ekosistem. Lebih jauh, orientasi pembangunan kita masih bertumbuh pada pembangunan yang beraliran pertumbuhan ekonomi yang kuat. Di Indonesia, pasal 33 ayat 3 konstitusi menekankan pemanfaatan sumber daya alam untuk kemakmuran rakyat yang sebesar-besarnya tanpa menyinggung integritas ekologis. Kemudian, hasil amandemen keempat di tahun 2002 telah menambahkan dan melengkapi pasal 33 ayat 3 dengan pengenalan prinsip berkelanjutan, berwawasan lingkungan, dan berkeadilan sebagai safeguard dari pasal 33 ayat 3 Undang-Undang Dasar 45. Tetapi sekalipun ada 3 pasal dalam konstitusi kita yang berpotensi menjadi pasal-pasal yang bisa dikategorikan sebagai green constitutions, pada kenyataannya pelaksanaan pembangunan ekonomi kita tetap merujuk pada pola heavy economic growth. Undang-Undang Nomor 6 Tahun 2023 tentang Cipta Kerja merupakan contoh nyata bahwa kebijakan pembangunan kita telah mereduksi pentingnya aspek lingkungan hidup dan bahkan memungkinkan mengecualikan critical natural capital atau CNC disubstitusi dan digantikan, dialihfungsikan dengan man-made capital yang tentunya bertentangan dengan prinsip strong sustainability. Salah satu putusan yang menegaskan bahwa kita menganut atau kita harus menganut pembangunan berkelanjutan beraliran kuat atau strong sustainability adalah putusan Mahkamah Konstitusi nomor 35 tahun 2023 yang menolak gugatan sebuah perusahaan nikel yang meminta Mahkamah Konstitusi untuk menafsirkan bahwa pertambangan boleh dilakukan di kawasan pesisir dan pulau-pulau kecil berdasarkan Undang-Undang Pengelolaan Wilayah Pesisir dan Pulau-pulau Kecil. Pada pertimbangannya, putusan tersebut menafsirkan pasal 28H dan pasal 33 ayat 3 dan pasal 33 ayat 4 Undang-Undang Dasar 45 sebagai dasar dari penerapan prinsip keberlanjutan beraliran kuat atau strong sustainability. Kelemahan mendasar dari hukum lingkungan kita karena sifatnya yang terfragmentasi atau terisolasi. Hukum lingkungan kita isolated. Pendekatan reduksionis ini mengabaikan sifat adanya saling ketergantungan antara human beings dan other living beings atau interdependency. Contohnya, Undang-Undang Cipta Kerja memperkenalkan pengecualian dengan meniadakan perantara tata ruang dan membuka peluang konversi hutan lindung, hutan konservasi untuk proyek strategis nasional, termasuk tambang, reklamasi, dan dumping bahkan di zona inti kawasan konservasi laut. Dengan demikian, ecological limits, ecological integrity, dan ecological primacy tidak dikenal setelah Undang-Undang Cipta Kerja diberlakukan. Dan hukum justru memfasilitasi eksploitasi dibanding menjaga resiliensi ekosistem. Semua ini menunjukkan bahwa paradigma hukum kita belum menempatkan supremasi ekologi, keterbatasan daya dukung ekosistem, keadilan ekologis, sifat interdependency human beings dan other living beings, dan mengakui pembangunan berkelanjutan beraliran kuat sebagai fondasi utama law in the Anthropocene dalam kerangka planetary crisis. Disinilah kita membutuhkan seperangkat tools dan instrumen untuk mencapai keadilan iklim, climate justice. Beberapa tools yang perlu kita dalami dan pertimbangkan adalah: pertama, Piranti Safe and Just Planetary Boundaries yang diusulkan oleh Earth Commission tahun 2023 menunjukkan bahwa batas aman, safe boundaries untuk menjaga stabilitas bumi tidak cukup. Kita juga perlu batas yang adil atau just boundaries untuk meminimalkan dampak buruk terhadap manusia dan alam. Pendekatan ini berpijak pada 3 dimensi keadilan: interspecies justice dan earth system stability yang menolak pandangan manusia sebagai pusat dan menegaskan keterhubungan semua makhluk hidup. Yang kedua, intergenerational justice yang menekankan tanggung jawab generasi kini terhadap generasi mendatang, secara intragenerational justice yang mengharuskan relasi adil antar negara, komunitas, dan individu. Dengan demikian jelas bahwa batas adil seringkali lebih ketat daripada batas aman. Dan hal ini menegaskan bahwa keadilan tidak dapat dipisahkan dari keberlanjutan. Karena itu, safe and just planetary boundaries yang perlu kita dorong dan bumikan di berbagai negara. Di Indonesia, Badan Perencanaan Pembangunan Nasional sudah seharusnya mulai melakukan scaling down konsep ini ke dalam perencanaan nasional. Hal inilah yang sedang diperjuangkan IOJI, ISEL bersama Universitas Gajah Mada dan universitas-universitas lainnya melalui nota kesepahaman yang telah ditandatangani 2 minggu yang lalu bersama-sama dengan Bappenas, BRIN, dan Kementerian Lingkungan Hidup, berusaha memastikan bahwa kerangka ilmiah global ini benar-benar dapat diterapkan dalam konteks Indonesia sebagai cara menerjemahkan prinsip ecological limits. Kedua, sedikit lagi Pak Moderator, berdasarkan tipologi keadilan iklim, berdasarkan Eloy Loren 2023, prinsip-prinsip ini memberikan arah bagaimana kebijakan iklim harus dijalankan. Ada keadilan rekognitif, yakni pengakuan hak dari kelompok rentan seperti perempuan, anak, masyarakat adat, penyandang disabilitas, dan kelompok miskin. Ada keadilan prosedural, yaitu memastikan partisipasi bermakna dari kelompok tersebut dalam pengambilan keputusan. Ada juga keadilan distributif yang menuntut negara beremisi tinggi dan kelompok kaya menanggung porsi lebih besar dari upaya mitigasi. Dan ada keadilan restoratif yang memastikan adanya pemulihan bagi mereka yang telah dirugikan oleh dampak krisis iklim. Yang ketiga, penguatan gerakan climate litigation, tadi sudah disampaikan oleh saudara Reynaldo Sembiring. Metode gerakan litigasi ini menegaskan peran penting lembaga peradilan dalam menegakkan keadilan iklim melalui constitutional review di Mahkamah Konstitusi kalau di Indonesia, permohonan advisory opinion seperti yang dilakukan di ITLOS dan ICJ tentang perubahan iklim, maupun gugatan pemulihan lingkungan. Pengadilan dapat memastikan negara dan korporasi bertanggung jawab atas tindakannya. ICJ dalam advisory opinion tentang perubahan iklim menegaskan bahwa keadilan iklim dan hak asasi manusia tidak dapat dipisahkan. Iklim yang stabil merupakan prasyarat bagi terpenuhinya hak hidup, kesehatan, pangan, air, dan perumahan. Lebih jauh, ICJ menegaskan bahwa negara memiliki kewajiban di bawah customary international law, antara lain precautionary duty untuk mencegah kerusakan lingkungan lintas batas, transboundary harm, dan duty to prevent significant harm to the environment. Dengan rujukan ini, prinsip seperti indubio pro natura dalam keraguan keberpihakan pada alam, serta judicial proactivism yang sejalan dengan Undang-Undang Kekuasaan Kehakiman dan Undang-Undang Mahkamah Agung memperoleh legitimasi moral sekaligus dasar hukum internasional agar para hakim berani menempatkan kepentingan ekologis di atas segalanya. Keempat, dan tak kalah penting adalah vibrant civil society. Gerakan masyarakat sipil yang dinamis, kritis, dan berdaya adalah syarat mutlak bagi keadilan iklim. Oleh karenanya perlindungan hukum harus diberikan melalui instrumen hukum seperti anti-SLAPP untuk melindungi aktivis lingkungan, peneliti, awak media dari kriminalisasi. Sebab masyarakat sipil yang bebas dari intimidasi bukan hanya saja mampu sebagai pengawas independen, tapi juga sebagai penggerak kesadaran publik dan mitra strategis negara dalam mendorong perubahan struktural. Bencana iklim adalah cermin paling nyata bahwa kita telah memasuki epos Anthropocene, periode geologis baru. Namun kita tidak boleh berhenti pada rasa takut atau keputusasaan. Kita memiliki pilihan, kita memiliki arah, dan kita memiliki instrumen untuk memperjuangkan keadilan iklim. Safe and just planetary boundaries mengingatkan kita bahwa keadilan tidak bisa dipisahkan dari keberlanjutan. Tipologi keadilan iklim menegaskan bahwa semua kelompok, terutama yang paling rentan, harus mendapat pengakuan, partisipasi yang bermakna dalam pengambilan keputusan, pembagian yang adil, dan pemulihan lingkungan. Litigasi iklim membuka ruang akuntabilitas hukum agar negara dan korporasi tidak lagi bebas merusak bumi. Dan masyarakat sipil yang vibrant adalah penjamin bahwa suara publik tidak akan pernah dibungkam. Dengan kata lain, climate justice bukan sekedar konsep, melainkan arah perjuangan bersama. Perjuangan untuk memastikan keadilan bagi generasi kini dan mendatang, serta aman dan layak huni bagi seluruh makhluk hidup yang ada di bumi ini. Jangan sampai kita mengabaikan biaya lingkungan yang tinggi, high environmental cost, sebagai eksternalitas, dan tindakan kita mengakibatkan bencana yang menjadi beban berat bagi generasi mendatang, seperti yang terlihat dari ilustrasi gambar ini sebagai penutup. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Terima kasih banyak Pak Ota. Yeah, we already hear from Pak Ota about how our national law does not put climate justice as our priority, and about how we struggle to put the climate justice to be our priority of our national law. And Pak Ota also already mentioned about meaningful public participation, and I would like to invite now Ibu Dr. Wiwi Awiyati to share more about the meaningful public participation. We would like to hear from her about how have Indonesian courts responded so far to questions of public participation, and what more can be done to make sure the judicial outcomes are legitimate and responsive to climate justice. Your time is 10 minutes. Mbak Wiwi, the floor is yours.
Thank you, Mas Gama. The Honorable Chief Justice Debra Mortimer, Federal Court of Australia, and all the delegation. Yang Mulia, Gusti Agung Sumanatha, Chair of Civil Chamber Supreme Court of Indonesia, Mas Achmad Santosa, Bang Laude Syarif, Renaldo Sembiring, distinguished participant, good afternoon. Thank you for inviting me to share my thought on two connected topics. First is the importance of public participation in environmental decision making, and second, how Indonesian court respond to environmental cases, including protection against SLAPS lawsuit. Allow me to start with the close connection between public participation, democracy, and environmental rights. Community involvement as a form of public participation in policy making and decision making process related to the environment, it is very important. First, through public participation, we ensure that decision and policies taken reflect the public interests and are implementable and sustainable. The second one, through public participation, a variety of perspectives, local knowledge, and community interests will be taken into account. This will help to bridge existing gap and also rights.
Recording in progress.
Another important aspect in terms of recognizing participation is the Second Amendment of the 1945 Constitution, which affirmed that participation is a human rights issue. How is the legal framework for public participation in decision-making process and related to the environment constructed in our legislation? Regulation concerning environmental rights are part of the human rights, both substantive and procedural. An analysis of this regulation shows that there has been progressive development since the first environmental law. Next, please. Sorry, yeah. Next. Okay, thank you. Since the first environmental law was enacted in 1982 to law number 32, 2009, there has been increasing openness to community involvement. One of the important is the shift from the terms community participation to community involvement. It shows the strength of the community in fighting for its right. In practice, public participation happens through mechanisms like environmental impact assessment, community hearing, and access environmental information. Civil society organizations and environmental activists also play a vital role in ensuring that community voices are heard. Unfortunately, participation is often just tokenistic, done to meet formal requirements. Technical reports are not accessible, and the marginalized group often struggle to be heard. True participation requires transparency, capacity building, and the real political will. Participation is not just a box-ticking exercise. It is the foundation of sustainable and just environmental governance. There has been a regression in the regulation of public participation in job creation law, which already mentioned by Pa Ota as well. The job creation law limits the community involvement not only to those who are directly affected only. The EIA assessment community also been abolished and replaced by an environmental feasibility assessment team, consists only of the central government, regional governments, and certified expert. The community and environmental organization are no longer part of the environmental feasibility assessment team. Allow me to address the issue of public participation and SLAP. A key innovation in Indonesian law is the anti-SLAP provision in Article 66 of Environmental Management Act. It says that everyone, next please, anyone who fights for the right to good governance, good environmentals cannot be criminally prosecuted or civilly sued. This is meant to protect NGOs, activists, and citizens to speak out in a good faith. However, individuals who fight for the environment often become the target of counter lawsuits known as strategic lawsuit against public participation, or SLAP. SLAP has since evolved not only in the civil sphere, lawsuit or damages, but also in Indonesia, it becomes a part of the criminal sphere, defamation, or insult. SLAP now oftenly translated as strategic litigation against public participation. Cases such as Newmont case 2004, Tumpang Pitu mine, the Raja resort in Batu Malang, East Java, and Karimun Jawa are a few examples of the lack of community involvement in decision-making process or policy-making process, which have resulted in community rejection and environmental damage. And the one who speak out in this case or issues being sued or convicted. Now, what is the role of judges and court in fulfilling the rights to public participation in environmental cases? The role of judge and court rulings in enforcing environmental law is crucial. By upholding the principle of environmental democracy, transparency, and accountability, judges actually can ensure that environmental law is effectively enforced and that citizens' voices are heard in the decision-making process. Through their rulings, judges can contribute to a more inclusive, fair, and sustainable approach to environmental governance. With competent judges, the court, which are also considered independent institutions, have the power and quality to ensure long-term environmental protection compared to policymakers due to the slow pace of legislation-making process. How is the public participation in environmental decision-making considered and assessed by judges? Some of the decisions that include in my research shows that judges considered and assess public participation in environmental decision-making in three areas or three aspects. One is the procedural aspect of filing a lawsuit, including the right to sue, the basis for the lawsuit, and the interest of the plaintiff. The second is in the substance of the case. Judges look at the procedural aspect of public participation, which is compliance with the provision of law and regulation related to the public participation. And third, the quality of public participation itself, namely whether public participation have been carried out by appropriate participation based on the sufficient information and proper consideration of public suggestion, input and response, and whether the result of participatory input have been determining factor in environmental decision taken by government officials. It shows that most of the decisions are focused on point number 1 and 2. The decision indicating that judges have considered point 3 shows that the judiciary's understanding of ideal public participation is need to be improved, and that public participation is still restricted to the procedural spaces. Finally, allow me to highlight the importance of judicial activism in ensuring public participation and protection to the environment. This includes current and future generation, especially the most important challenge that we face, climate issue and climate justice. Judges will always be at 2 points of continuum between activism and self-restraint, pengakangan diri. Judicial activism is a form of judicial discretion that arises from the complexity of issues that must be resolved by judges in court. In the absence of adequate or formal laws, judicial issues, or when existing regulations are too general or ambiguous, in such circumstances, judges have an important role to play in ensuring that justice is upheld by interpreting the law broadly and taking moral and social principles into consideration. In summary, courts are crucial to ensure the existence of environmental rights, and the anti-SLAPP clause provides the shield for defenders, but without consistent application, its potential remains limited. Thank you.
Thank you very much, Ibu Wiwi, for highlighting the role of participation and the legitimacy in court processes. And the last one, last but not least, I will invite Dr. Laude M. Sharif, who will share about the role of civil society in pushing for environmental justice.
Thank you very much, His Excellency, Chief Justice of the Federal Court, and our guests from Australia, and of course, Pak Agung Sumanatha, Justice of Indonesian Supreme Court, speakers and audience. I have a 10 minutes, but I have a lot of slides actually, but most of them actually pictures. Because the previous speakers, they already talked about the difficulties in implementing Indonesian environmental law. I just want to make you understand a little bit about the context of Indonesia on the intersection between the environmental law and the governance in the aspect. Why it is actually important? Because we are operating in very difficult setting. If you look at the Indonesian Corruption Perception Index, our point it is only 37 today, meaning we are still very corrupt society. So that's why it is very difficult to enforce the environmental law. The two pictures, it show you in the left, actually, it is the lake, Sentani Lake in Papua, where they call it Cyclop Islands in the middle, and in the right side, it is actually close to my hometown, which is actually a small island of Kabaena, which has been destroyed by nickel mining. So we are operating on the right side. So if you please next, make it fast. So there are a lot of writing about the Indonesian archipelago. Indonesia is a string of emeralds on the equators, Max Havelaar say. And I keep on saying, you name it, we have it. Gold, we have it. Nickel, we have it. Every minerals that we actually have it. Of course, Australia maybe have more because they have like a big land, but we actually have it next. So if actually, yesterday I was invited by Justice Sumanatha because I have to teach in the Supreme Court. I always try to remind the justice or judge in Indonesia that according to Wendell Holmes, law is a product of politics. I mean, so the judges usually actually operating within the context of the politics of a country. It is depend which side they are going, but actually in Australia, yeah, we can actually say. If we actually look at, for example, Kevin Rudd, Julia Gillard, they cannot continue their prime minister period because of what? The people, they do not want them actually to be very, very strong aligned to climate movements in Australia, for example. And next, so this is the landscape of Indonesian politics. We have a lot of political party, and I think we are more complex than Australian politics. Next. So if you actually look at, in the previous governments, we have 575 parliamentarians, and 262 are actually business people. So how can you imagine that if you are operating in such environment? Next. Today's we have is actually the same. The business people always dominating Indonesian parliament. So never ever expect environmental justice in such environment where actually business and politics and law enforcement actually connected with such environment. Next. So even, I mean, this is a reality. Some ministers actually, most of them actually, they are ministers, but at the same time, also they are others of big minds. So how can you reconcile that? Next. Yeah, and we have the richest governors in Indonesia. The richest is actually the ladies in North Maluku and Andi Sumangeruka from my own province. They are the richest. And they are actually miners, nickel miners. That's the situation. So if you want to, what is the role of civil society? I tell you later, but actually just 1 minute for that. Next. Because the context is very important. So if you actually look at, for example, he's already in jail, but actually he passed away in jail, but because he actually take a bribe. In the left side, many people actually taking bribe for mining related. Next. And even this one, he's already in jail, now he's actually out and campaigning his wife to be the next governor of Southeast Sulawesi. I mean, next. So the negative impact of state capture corruption and conflict of interest in critical mineral exploitation, which is actually linked, connected with the climate change, it is very real and it is not easy. Next. So look at that. Mas Ota and Mbak Wiwi already explained about the impact of this situation into our policy and legislation development. Next. For example, in just 2 weeks, they just changed the KPK law. When I was a commissioner of Corruption Eradication Commission, they just changed in 2 weeks from independence into part of the executive. They revised the mining law. There's a good mining law, only 4 weeks without any public consultation. They created job creation law, which is actually changed everything's good about Indonesia. Next. So the job creation law, which is already actually explained by Mas Ota and Bu Wiwi, it is actually invalidated some good provision of environmental law, small islands, and mining laws, and many others actually. Next. So look at that. For example, before that, in our forest law say that every province, at least they have 30% of forest cover. Now, it's actually gone, everything. Next. So the bitter reality of energy transition on whose expenses? Because Indonesia trying to play a role as one of the main source of nickel. Yeah, we have 21% of nickel mining of the world. Australia have 20%. So we just actually high 1% compared to Australia. But I mean, that's the reality. Next. Yeah. Unfortunately, it is different from Australia because those nickel mining actually located in small islands, very even small island. I just showed the story. Next, look at this. This is actually in Obi Island with the richest governors. It is only 2.5 square kilometers. Next, and you can actually see the one and only river in that area. It is actually heavily polluted. Next, and look at that. I mean, the Portuguese, the Dutch, and many other European countries came to Maluku because of what? Because they call it Spice Island. They like it. Now, look at that. Next. And this is my own island. This is even smaller, but they, by law, this is actually prohibited for mining because this is considered small island. But no. Next, you can see the picture of it. Next, this is the clove plantation owned by the people, bulldozed by people. Why? They don't have a title on the land. And they say, okay, they just give it license to those people from Jakarta and maybe from China, some of them, to mine that clove plantation. Next. This is the one and only rivers as a source of drinking waters of the people in that Cabana, it's Wawoni Island. And you can next, you look and see that. Yeah. This is actually the water of peace. So actually the government have to bring more tank. Next. And look at that. This is Cabana Island. I already put the governors in jail because of this when I was a commissioner of KPK, but still continue. And now the current governor have to concession in that small island. Next. Raja Ampat events. Next. I'm run out of time because I'm too excited. Next. So if you are interested, you can read it. Self-promotions. Next. Yeah, on that one, next again. Yeah, but This is a lack of enforcement by the government. You can easily find irresponsible mining in every corner of Indonesia, but only a few cases actually reach the court. The investigators of Ministry of Natural Resources and Energy, they are almost 100 of people. They never actually bring one case to the court. Never in the history of Indonesia. Yeah, on a mining related. Why? Yeah, you can imagine. Yeah. The police, they investigate small, even the Ministry of Environment, only small cases, never big corporation. Next. So what is actually the role of CSO in environmental justice? This is next. Yeah, next. It is not important. Yes, we actually do what I'm doing now. We have to do pressure from outside. We are demanding the transparency and accountability of the government, a law enforcement agency, parliamentarian, the judiciary. And the second, of course, we strategic litigations, but not many. If you actually look at, but we are actually have to appreciate the Indonesian court. They are more advanced compared to the legislators and the executive. Because they have some kind of tendency to work with us. It's not because Pak Agung actually here, but actually, but actually they have better alignment to the environment. And next, apart from that, and again, sorry for self-promotion, I'm in the board of ISIL. We are assisting the government from inside in research and study, legislation drafting. I can say it, Pak Agung, that actually, for example, the Supreme Court regulation on how to adjudicate environmental cases, of course it's drafted by them, but we actually helping them to draft that, for example. Yeah, grooming, training and capacity building, Mas Otamba, me myself, we've been actually teaching in the Supreme Court since more than 20 years. Yeah, and so that's why, and this is actually funded by Australian government. Mostly, not all of them, but so that's why I think we need to continue this. And also grooming reform champion from within the government. Because not many people, actually not all Supreme Court justice of Indonesia just like Pak Agung. Some of them, they have a different opinion. Because we do not have president here in Indonesia, different from Australia. Yeah. It is not actually mandatory to follow one president. Yeah, you are free, and they can come up with many innovation. Next. So this is I'm saying, never ever dream of an ideal environmental justice if you are living in corrupt society. You can quote me on that. And next. So that's why, next. So that's why it is important. If you are fighting for corruption, it is just like being a mother. You have no right to stop, and giving up is not an option. Assalamualaikum.
You still have 1 minute actually, Pak Aude. Thank you so much for showing us not only bitter reality of energy transition, but also the reality of political corruption in Indonesia today. And thank you all for your thoughtful and wonderful responses and the presentation. We now move to the question and answer session. I think we have around 10 minutes, and questions are welcome from the audience here in the room, as well as from participants joining online, either in Indonesian or English. And please keep your question short, and please introduce your name and institution. One here, the other one, two, and here. Maybe last one? Okay, we only have one round for question and answer. Okay, 3 questions after this. Okay, silakan Mbak. Mikrofonnya boleh dibantu? Oke.
Selamat sore. Selamat sore. Pertanyaan bagi panelis dari Indonesia. Banyak gugatan iklim di Indonesia menghadapi hambatan seperti mulai dari lemahnya eksekusi putusan. Saya mau bertanya, jadi bagaimana para penggugat dapat memastikan gugatan mereka benar-benar menghasilkan perubahan kebijakan dan misalnya secara hypothetically dalam konteks proyek strategis nasional, bagaimana peran peradilan dapat menahan tekanan politik dan ekonomi demi melindungi keadilan iklim. And for the Honorable Chief Justice from Australia, in Australia, courts often ask to balance development framed as national interest. How should the judiciary navigate these tensions? And how might these experiences guide countries like Indonesia, where PSN projects frequently clash with environmental law?
And your name and institution?
My name is Maria. I'm from Jentera.
Oh yeah, thank you. Next, Mbak yang di belakang. Ya.
Perkenalkan, nama saya Sonya, saya dari Tempo. Saya ingin bertanya, barangkali lebih ke statement bagaimana seberapa mampu climate litigation ini menekan kerusakan alam di Indonesia dan dengan political will yang ada di Indonesia juga, termasuk ambisi Presiden untuk 8% di 2045. Terima kasih.
Thank you. Last one.
Mohon maaf, saya punya banyak pertanyaan, jadi saya ringkas jadi 3 pertanyaan aja.
Namanya boleh, Mas?
Perkenalkan, nama saya Julianto, saya dari Jentera. Pertanyaan pertama, bagaimana bisa hakim menjaga kepastian hukum, tapi sekaligus memberikan keadilan lingkungan yang kadang butuh tafsir hukum yang lebih maju dari sekedar bunyi undang-undang? Apakah sikap hakim yang aktif dan berani dalam kasus iklim itu wajar sebagai tafsir hukum, atau justru berbahaya karena melewati batas kekuasaan hakim? Yang kedua, kalau ilmu pengetahuan soal iklim sering penuh ketidakpastian, probabilitas dan lain-lain, standar bukti apa yang sebaiknya dipakai hakim? Beyond reasonable doubt atau preponderance of evidence? Dan yang terakhir, mengingat bahwa litigasi perubahan biaya kerugian iklim bla 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 melalui bagaimana Mahkamah Agung melalui doktrin hukum dapat mengatasi tantangan pembuktian kausalitas yang kabur dalam hukum pidana dan perdata? Sekian, terima kasih.
Okay. Terima kasih, Julianto. Do we have question from Zoom? Ada atau tidak ada? Ada, okay. So we have one question from Zoom. So we collect the question first, and after that, all the speakers will respond to the questions. Okay. Can we show it in the monitor? Okay. While we are waiting, so I think there are 3 questions or 3 more questions, and okay, tulisannya agak kecil-kecil ya. There's a very small fonts. Okay. Okay, someone send it to me. That's technology. Okay. Thank you. And also technological problem, the Wi-Fi is very slow. Okay, I can read it here. The first question is from Bambang Mulyono. Together, Australia and Indonesia can collaborative action on climate adjudication capacity building across Asia Pacific judiciaries, promote comparative legal frameworks for climate resilience and environmental justice, together to support transnational judicial dialogues on climate migration, loss and damage, and right-based climate governance, and also reinforcing the judiciary's role as a guardian of intergenerational equity. Climate threat, I think this is not a question, okay. The question is, so how to accelerate Australia and Indonesia's judiciaries plus ASEAN judicial institutions to play pivotal roles in advancing climate justice, accountability, and legal innovation? That's the first one. The second one is from Tamimi. Okay, that's not the question. The next question is from Andre Trisandi. Apakah di Australia ada gugatan perubahan iklim sebagai alasan utama, bukan sebagai alasan ikutan dari pembalakan liar, kebakaran lahan gambut, dan lain sebagainya? And the last question, this is specified for Bang Reynaldo. Apa keuntungan litigation with climate change as the central issue dibandingkan tier lainnya, dan mana yang lebih baik? Okay, that's all the question from online and offline. And I think there's only a few questions that specified to Justice Mortimer, and some other is for our discussions. I will invite first Chief Justice Mortimer to respond maybe one and more questions. Yeah. Please.
Thank you. I'm not sure if I got the sense of some of those questions, but I'm going to give two answers that I think might be relevant to a number of questions. So the first is the benefit of strategic litigation and bringing a claim to court is that it encourages transparency, because once you are in a court environment, then the parties have to produce evidence and documents, and particularly if you are litigating against government or against big corporate respondents, they can't avoid the coercive processes of a court. And sometimes that means you get access to information about activities that you otherwise cannot get information about. So, and it means that the information about how people are carrying out their development activities, what the environmental effects of those activities are, becomes public information. And that is a very big benefit if you are trying to change behaviour. The second thing I think that a number of the questions dealt with is, and I think it's important to remember that when we are dealing with the question of climate change and how the legal system deals with it, that it's a global problem and every justice system around the world has to deal with it. And you are seeing, and some of the speakers talked about this, cases coming out of every legal system in the world about this, with evidence, with arguments, and unlike many areas of the law that might be very specific to one country and one legal system, here we have the benefit and the prospect of looking at what is happening all over the world in different justice systems and drawing from it and getting ideas from it. And I think just like it's a global problem, then the courts are more likely in this problem to be working together and drawing off what each court is deciding than in many other areas of the law.
Okay, thank you so much, Chief Justice Mortimer. Next, I will invite Pak Dodo to respond some questions, please.
Terima kasih. Ada beberapa pertanyaan. Pertama, tadi ada dari Kak Maria ya, hambatan dari gugatan iklim untuk eksekusi dan legal standing serta bagaimana menghadapi PSN. Mungkin pertama kalau untuk eksekusi itu jadi masalah utama ya. Saya pikir itu Pak Agung juga pasti jadikan prioritas begitu ya untuk menyelesaikannya. Nah, tapi kalau untuk legal standing dalam beberapa pemantauan atau misalnya saya mencoba membaca beberapa data, sebenarnya tidak terlalu banyak masalah soal legal standing. Nah, legal standing itu agak bermasalah kalau kita memisahkan antara masalah kehutanan yang juga punya hak gugat organisasi kehutanan misalnya begitu, masalah persampahan yang juga punya hak gugat organisasi persampahan, dengan masalah lingkungan. Permasalahannya bisa muncul kayak begitu. Jadi seolah-olah kalau tidak secara spesifik bilang ini organisasi untuk kehutanan, untuk persampahan, dianggap masalah nanti legal standingnya. Tapi sebenarnya itu udah ada jawaban di Perma. Perma 1 2023 itu sudah bilang, kasus-kasus lingkungan hidup termasuk kasus apa? Termasuk kasus-kasus banyak itu, mulai dari perikanan, kelautan, energi, persampahan, kehutanan, segala macam. Sampai perubahan iklim. Jadi menurut saya masalahnya sudah clear di situ. Jadi tinggal mengacu kepada Perma. Dan hal yang menarik dari Perma 1 2023, Peraturan Mahkamah Agung nomor 1 tahun 2023 adalah Perma ini menempatkan perubahan iklim bukan sebagai sektor gitu. Jadi kan kalau kita misalnya baca, kayak tadi kan sambutan dari Bang Arya kan bilang ada environmental pollution, ada loss biodiversity gitu ya, ada climate change gitu. Seolah-olah kan sering ditafsirkan itu sektor gitu. Nah, Perma itu meletakkan perubahan iklim itu sebagai masalah besar dari lingkungan begitu. Makanya muncul di situ. Masalah-masalah lingkungan itu juga masalah-masalah perubahan iklim juga merupakan masalah-masalah lingkungan. Jadi kira-kira menurut saya itu udah clear. Dan yang perlu diingat juga di bagian menimbangnya Perma 1 2023 itu spesifik itu untuk mewujudkan keadilan lingkungan dan keadilan iklim. Jadi kalau pertanyaannya apakah bisa menggunakan Perma sebagai salah satu landasan dalam melakukan advokasi atau litigasi perubahan iklim, jawabannya bisa karena sejak bagian pertimbangan sudah membuka itu. Itu dari pandangan saya. Kalau soal eksekusi, nah ini memang pekerjaan rumah yang panjang, tetapi catatan saya sebenarnya ada 3 perusahaan yang sudah melakukan eksekusi tapi dengan cara yang agak unik. Jadi dia melakukan mediasi setelah putusan. Jadi itu ada di Kalista Alam, Surya Panen Subur di Aceh, itu sebelahan, satu lagi di Nasional Sago Prima di Riau. Jadi mereka membayar biaya ganti ruginya, tapi kemudian dalam konteks melakukan eksekusi pemulihannya, mereka melakukan secara mandiri mengikuti ketentuan dari pemerintah. Kira-kira begitu, diawasi oleh pemerintah. Nah, sayangnya ini memang agak sedikit tricky gitu, karena di dalam petitum mereka, Kementerian Lingkungan, mereka itu kan meminta pembayaran biaya ganti rugi dan biaya pemulihan, kira-kira begitu. Tapi kemudian pemulihan di-convert menjadi tindakan pemulihan secara mandiri. Ini mungkin harus dicari polanya menurut saya. Tapi dan PR yang berikutnya adalah Kalista Alam dan Surya Panen Subur sempat itu eksekusinya berjalan dengan lancar karena kita coba dapat beberapa datanya. Itu kasus pembakaran hutan di Aceh, Rawat Ripa. Tapi kemudian terakhir saya dapat data dari teman-teman di Aceh, ternyata sempat mandek. Nah jadi ini juga jadi pertanyaan penting juga gitu. Jangan-jangan eksekusi sukarela itu untuk pemulihan punya kelemahan-kelemahan. Yang berikutnya dari Kak Julianti, Bang Julianti ya. Bagaimana menjaga Julianto ya? Kepastian hukum dan keadilan lingkungan. Ini menurut saya nanti mungkin yang paling inilah ya, masih banyak senior sini Aisal yang bisa merespon dengan lebih baik daripada saya. Tapi kalau saya melihatnya begini, kayaknya kita perlu, dan ini sudah jadi pemikiran lama ya, kita perlu meletakkan atau memberi informasikan kepada para penegak hukum bahwa ada ontologi hukum dan ontologi sains yang itu beda ruangnya. Ontologi hukum itu bicara kepastian. Nggak ada pencemaran tanpa ada baku mutu yang ada diatur dalam undang-undang lingkungan. Sementara ontologi sains, kalau nggak ada standarnya, once saintis bilang ini sudah terjadi pencemaran, itu diterima. Tanpa ada pro regulasi gitu. Jadi apakah bisa sebenarnya sains itu berkelindan dengan hukum? Menurut saya harusnya bisa gitu. Tapi secara epistemologi ilmu pengetahuan, ontologi sains itu ada ruangnya, ontologi hukum ada ruangnya, ontologi hukum bicara kepastian benar, ontologi sains itu bicara lebih besar, bicara realitas, bicara dampak pencemaran dan segala macam. Dalam satu kasus itu pernah terjadi, nanti coba cek kasus Cikijing di Jawa Barat. Itu hakimnya sangat ciamik menggabungkan antara dua ini, ontologi sains dengan ontologi hukum. Jadi tadi kepastian dan keadilan lingkungan itu bergabung di kasus itu, jadi silakan nanti dibaca gitu. Dan kausalitas kabur dalam peradilan pidana untuk litigasi perubahan iklim, memang kita belum punya litigasi perubahan iklim untuk pidana. Gitu, karena kita memang tidak menempatkan CO2 gitu ya, ekuivalen itu sebagai standar yang bisa dipidanakan gitu ya, masuk dalam baku mutu dan seterusnya. Tapi untuk perdata sebenarnya kausalitasnya, saya setuju gitu, dalam perdata ini kan yang paling susah sebenarnya pembuktian kausalitas dibandingkan pembuktian atas kesalahan kerugian gitu ya, atau kalau dia pakai strict liability abnormalinya gitu. Tapi memang di kausalitas ini menurut saya yang agak susah dalam bacaan saya ya sebagai peneliti ya, bukan sebagai hakim tentunya, adalah memang di aspek valuasinya gitu. Mohon koreksi Pak Agung nanti kalau keliru. Karena valuasi ini tuh ranahnya ranah yang memang mau tidak mau kan hakim akan berada dalam wilayah hakim bersifat pasif, nungguin gitu. Cung, pihak ini ngasih hitungan valuasi segini, ini ngasih hitungan valuasi segini. Sementara metode valuasi itu banyaknya minta ampun, apa aja sah begitu. Nah itu sering membuat kabur. Seberapa pulihkah menurut valuasi ahli A, bisa jadi beda seberapa pulih menurut ahli B. Nah, menurut saya ini yang kesulitannya, tapi saya pikir Mahkamah Agung sudah ada beberapa langkah-langkah begitu ya. Mulai dari perma yang mengatur soal pembuktian dan juga soal double standar dan seterusnya. Yang kedua sebenarnya beberapa capacity building untuk itu. Nah yang terakhir, apa keuntungan dari perubahan iklim sebagai isu utama dibandingkan tier lainnya? Sebenarnya bukan soal keuntungan ya dari Mas Andre ya, tapi lebih kepada apa tujuan dari sebuah litigasi gitu. Ini paling paham Kak Asvin lah sini ya, saya harus berguru sama dia nih kalau soal strategic litigation. Jadi kira-kira itu strategic litigation itu bukan sesuatu yang bisa datang begitu aja gitu. Itu pasti ada konsep membangun apa yang mau diubah, apa yang mau dicapai kayak gitu. Tadi Chief Justice Debra sudah sampaikan, jangan melompat terlalu jauh kira-kira begitu kan. Gitu. Tapi kalau menurut saya adalah apa masalah utama yang mau kita selesaikan? Apakah memang masalah lingkungannya? Maksudnya gini, masalah pencemarannya yang yang ada di depan mata gitu ya, membatalkan izinnya, atau memang kita mau mengangkat ini sebagai masalah perubahan iklim gitu supaya penanganannya lebih multisektor. Lebih di situ gitu. Nah, ketika dia diadres sebagai masalah perubahan iklim, menurut saya itu dimensi mengargumentasikannya dalam gugatan itu bisa lebih banyak menurut pendapat saya. Dia bisa cross kemana-mana gitu. Jadi dalil-dalilnya akan sangat variatif dan sangat kaya. Mungkin kalau dibilang keuntungan lebih ke situ. Tapi kalau lebih dari segi strategic litigation menurut saya ya itu tergantung dari pilihan para pihak atau korban. Dia mau arahnya mau kemana nih begitu. Nah itu kira-kira. Yang PSN saya pikir begini sih, PSN itu satu-satunya regulasi kita bisa cek gitu ya, yang hampir nggak ada partisipasi publiknya sejak dalam penetapan. Satu-satunya regulasi di Indonesia, kayak hampir semuanya ada. Mau bikin apa penetapan keputusan untuk pendirian pabrik itu ada AMDAL, ada partisipasinya. Tata ruang kawasan lindung itu mau bikin kawasan strategis nasional, ada kawasan budidaya, kawasan industri, ada ruang partisipasi. PSN itu sama sekali nggak ada. Itu yang menurut saya paling berbahaya dari PSN ini. Itu saja, terima kasih.
Thank you, Bang Dodo. Next, I would like to invite Pak Ota.
Climate litigation merupakan satu opsi yang memang harus didorong untuk memperjuangkan ecological justice, termasuk di dalamnya climate justice. Tapi kalau boleh saya mengamati, mencermati potensi itu, menurut saya sangat besar. Jadi kalau berbicara Mahkamah Agung, dia kan sebagai benteng terakhir dari perkara-perkara yang diajukan. Apakah itu perkara perdata, PT UN atau pidana. Lalu di Mahkamah Agung itu mungkin, koreksi kalau saya keliru, satu-satunya di dunia di mana bukan hanya saja mereka mengeluarkan pedoman penanganan perkara lingkungan yang tidak diatur di undang-undang saja, diatur dalam pedoman itu. Seperti citizen lawsuit, diatur di mana? Tapi dengan secara proaktif mereka masukkan di situ. Lalu penerjemahan prinsip-prinsip precautionary misalnya, precautionary principle. Dan anti-SLAPP itu ada 2 bab. Anti deceptive itu perlindungan hukum buat pejuang hak-hak atas lingkungan hidup yang sehat dan baik. Yang kedua, Mahkamah Agung itu memiliki mekanisme sertifikasi hakim lingkungan. Mau menangani perkara lingkungan harus punya sertifikatnya terlebih dahulu melalui satu pendidikan yang lumayan panjang menurut saya. Kebetulan Pak Laude, Mas Dodo, saya, Mbak Wiwi itu menjadi pengajarnya seperti itu. Nah, dan banyak juga kita temukan putusan-putusan yang menurut saya progresif. Cuma memang saya kira ini sebuah proses ya. Sepertinya perlu ada satu library khusus di Mahkamah Agung atau di Pusdiklat yang isinya adalah mengupdate seluruh putusan-putusan lingkungan. Kalau perlu diterjemahkan dalam bahasa Indonesia. Jadi itu akan berpengaruh terhadap merumuskan keputusan-keputusan menjadi sangat runtut dan sangat komprehensif. Sebagaimana putusan-putusan yang ada di luar negeri misalnya. Nah jadi kalau saya sangat positif melihat ada gerakan climate litigation atau environmental litigation. Kalau di MK itu 1 bulan yang lalu itu ada seorang hakim konstitusi mewakili hakim, saya nggak tahu Mahkamah Agung juga ada yang hadir ya, hadir di satu konferensi dunia di South Africa, itu Global Justice Forum. Dan mereka bicara soal climate justice. Dan itu saya katakan tadi ada satu keputusan MK nomor 35 tahun 2023 yang menafsirkan pasal 33 ayat 4 adalah sebagai landasan hukum menerapkan mazhab pembangunan berkelanjutan beraliran kuat. Bayangkan tuh, strong sustainability. Yang namanya strong sustainability, seluruh critical natural capital cannot be substituted, cannot be replaced by man-made wealth. Jadi menurut saya itu progresif. Tetapi masalahnya putusan Mahkamah Agung itu tidak nyambung dengan kebijakan pemerintah. Jadi seharusnya kan nyambung begitu. Nah jadi kalau tidak nyambung itu selalu yang membuat mengkapitalisasi putusan-putusan itu adalah kita-kita ini, akademisi, masyarakat sipil, dalam berbagai seminar dan lain sebagainya. Nah jadi sekali lagi kalau menurut saya sangat potential climate litigation. Hakimnya Pak Agung ini terus menerus ada pokja lingkungan di sana. Pokja lingkungan itu bukan hanya hakim agung semua isinya. Ada orang-orang seperti Pak Laude, ada Dodo, ada Mbak Wiwi gitu ya. Kebetulan saya tidak masuk sih di situ. jadi dikeluarin sama Mbak Wiwi soalnya. Nah jadi menurut saya itu sangat bagus banget loh. Sangat bagus. Jadi di Mahkamah Agung itu kalau tidak bicara hukum lingkungan, tidak bicara litigation lingkungan, itu udah out of fashion. Semua ingin, benar gak Pak, koreksi saya, semua ingin bergabung dalam percakapan isu itu. Gitu. Dan yang saya tahu persis, Mahkamah Konstitusi lumayan 4 orang minimal sudah paham betul tentang persoalan-persoalan yang terkait dengan sustainable development ini. Dan tinggal menurut saya betul kata Dodo, Mas Dodo, tinggal ini kan harus ada demandernya. Harus ada plaintiffnya. Artinya masyarakat sipil harus membenahi dirinya, membuat gugatan itu sebaik mungkin. Datanya sekomprehensif mungkin, sesahih mungkin. Jadi itu tantangan buat masyarakat sipil menurut saya. Terima kasih.
Terima kasih Pak Uta. Next,
Iya, saya akan jawab satu saja karena memang yang lain mungkin sudah terjawab, nanti juga akan dijawab oleh Pak Laude. Sebetulnya apa yang akan saya respon itu lebih layak direspon oleh Yang Mulia Pak Agung karena memang ini menanyakan mengenai kaitannya judicial activism. Jadi izin ya Pak Agung, saya coba untuk merespon. Jadi begini, kita mengharapkan hakim itu kan tidak hanya sekedar menjadi dalam bahasa ini corong undang-undang. Hanya apa yang tertulis dalam peraturan perundangan itulah yang dijadikan dasar untuk membuat putusan. Kenapa? Karena kalau kita bicara kepastian hukum, mungkin kita bisa lari ke undang-undang. Tapi bicara keadilan, itu beyond dari sekedar hanya peraturan perundang-undangan. Dan kita tahu banyak peraturan perundangan yang tidak pro pada lingkungan dan tidak pro pada masyarakat. Jadi itu satu hal begitu ya. Nah sayangnya, ketika banyak mengatakan sebetulnya sudah tidak ada lagi pembedaan antara civil law, common law, tapi semua mengatakan bahwa hakim civil law itu nggak boleh keluar dari undang-undang. Sudah beberapa kali dibuktikan dan sudah banyak putusan-putusan itu mengatakan itu tidak benar. Nah persoalannya adalah apakah para hakim ini mau membaca atau tidak? Karena kalau membaca undang-undang gampang sekali kita lihat ABC gitu ya. Tapi kalau kita lihat, saya masukkan dengan membaca, itu adalah membaca putusan-putusan pengadilan lain, keputusan pengadilan di luar negeri itu sebetulnya bisa dimasukkan menjadi dasar pertimbangan bagi hakim begitu. Nah persoalannya adalah berapa banyak hakim-hakim yang cukup mau membuat pertimbangan putusan dengan komprehensif, itu jadi persoalan juga di kita. Dan saya senang sekali di Jentera Law School ini didorong sekali bagaimana mahasiswa itu mencoba untuk tidak hanya membaca putusan tetapi juga mengkritisi putusan plus ditambah mencoba membangun argumentasi. Argumentasi hukum itu tidak banyak fakultas hukum konvensional yang mengajarkannya. Jadi salut buat Pak Dekan, Pak Arya dan juga mahasiswa Jentera. Nah hal yang juga menjadi penting dalam konteks judicial activism tadi adalah bukan hakim itu tiba-tiba out of the blue kemudian berpikir sangat berpro pada rakyat dan lingkungan atau kemudian mengatakan juga dengan pro natura, maka tanpa dasar hukum yang tepat atau kuat dia langsung memenangkan, itu juga tidak benar. Seperti tadi kata Justice Mortimer mengatakan hakim juga punya keterbatasan. Nah ada dua hal yang bisa membantu, satu hakim membaca, hakim kemudian menggali hukum, menemukan hukum, dan juga para penggugat itu juga membuat gugatan yang bisa membantu hakim untuk melihat dan mempertimbangkan meluas dari sekedar peraturan perundangan yang ada. Saya rasa itu, jadi dua belah pihak, penggugat dan hakimnya harus sama-sama open minded, terbuka dan mau belajar, itu maksud saya. Terima kasih.
Terakhir Bang Laude, silakan.
Terima kasih. Ada pertanyaan pertama tadi itu bagaimana berhadapan dengan tekanan politik. Jadi I think this is the most important questions. Other question it is actually important, but this is actually the most important for Indonesia. Ya, kalau okay, I speak English then. Because this is very important, because usually if you actually look at the landscape of Indonesian politics and you look at actually the role of small civil society, it is just like comparing giants and like small players. And the judiciary, unfortunately, they are not in the front. You are waiting, just you said, the judiciary actually waiting the case coming to them. And how many cases actually? Not many. So of course, strategic litigation actually have the potentials to awaken the society, or also the government, about the importance on conserving and protecting the environment and social justice. But it is very, very limited. And sometimes, in Australia, for example, the decision of the court, especially the federal court or the high court in Canberra, for example, it used as a main compass for the government, even the judiciary, because they have to follow it. Otherwise, they will be considered a bad government, for example. In Indonesia, the government, they don't even actually able to enforce the decision of the Supreme Court. I'll give you an example. There was one time illegal palm oil plantation in North Sumatra. Not small one, very big one. And the Supreme Court decided that that particular big plantation has to be taken by the government. And more than 10 years, almost more than 10 years, they never actually do it. The Attorney General Office just actually let it. So, I mean, until the owners actually pass away, so that big plantation still managed by his son. And his son Evans nominated himself to become the vice governor of North Sumatra at that time. Kalian ikut nggak tuh kasus DL Sitorus? DL Sitorus case, it's just a big plantation. They don't even enforce the decision of the Supreme Court. This is the new reality. And this is not only one case. There are many cases. Fortunately, the current government has taken over not all illegal plantation within the forest. But again, we still have a long way. We have to discuss it also about this one. But I mean, that particular plantation has been taken over by the government. That's so how we are going to face that? Yes, we have to work together. Academia, civil society, the court. If we actually work together, even though we are small, if we are representing, call it the right value of the nation, that I think people will actually support us. That's number one. That's why strategic litigations, even though very small, but it is actually have the potentials to realize environmental justice in Indonesia. And also, this is another important question about, you differentiated the science and the court, and also Dodo actually some kind of like enforcing it. I don't agree with that. Number one, yes, of course, number one, the court usually have to base her decision based on science. Based on science. Of course, there are a lot of argument about science. It is never 100%, but you have to find a science that actually accepted by the majority of the scientists. For example, if you're talking about climate change, of course, the opinion of IPCC. You are not following the decision or the opinion of Trump and his gang. So, if you are a student at Jentera, right, you have to be very careful with that if I come in to teach in this. No. The good decision have to follow the logic of science. I give an example, this Australian case, which is, I like it, Leach and Director General of National Park. I used to call it giant burrowing case. This is actually about small creature, but they call it giant in Australia because it is actually a small frog, a big frog. And this is, there is a planning to develop a road, and people actually arguing that in that particular area you cannot develop road because it is living the protected giant burrowing frog. And they actually filed the case to the Land Environmental Court. And friend of mine, it's not friend of mine, it is my guru, Justice Paul Stein, actually decided the court, which is the first in 1993, implementing what you call it precautionary principle. See, that's a science. We invite people to hear the case. And there are many other cases, but I mean, you cannot differentiate, okay, maybe the law actually have to follow the wrong science. No. We have to follow the right science. So I think it is very important for us. And again, I think the most important one for climate justice, we have to fix our society. We have to fix our political landscape. If we cannot fix those, it will be difficult to have environmental and climate justice in the next future. Sorry for being pessimistic.
Thank you so much, Pak Laude. And with that, we conclude this session, the Q&A session. And please give round of applause to our panelists today. Thank you for Chief Justice Mortimer, our discussants, and all participants for a very rich and fruitful discussion. After this, we actually have a concluding remarks from Pak Ota, but we are still waiting for Pak Ota. So maybe I can ask only one question for Chief Justice Mortimer, if I may. Given the differences between Australia and Indonesia in terms of legal system and also the public interest litigation, what lessons from your perspective do you think can be most useful for judges here in Indonesia?
That's a very hard question. You know, I think I'll go back to what some of the other commentators have said, that you, for your judiciary to give effective decisions, you do need an effective civil society. And you need a society that respects the rule of law, and you need a government that respects the rule of law and abides the court decisions. So you can't develop the judicial decision-making side of a problem like climate change without developing the respect for the court and the rule of law. And so I think we realise, and I think my colleagues also realise, that we are very fortunate in Australia that we have such a strong rule of law culture, and our government respects the decisions of our court, even if they're very difficult and even if they upset big policies for them. You know, we have such an entrenched respect for each branch of government that that's, I think, why some of our decisions can be effective. So we understand that you have a lot of challenges in that space, and we wish you well with them.
Thank you so much. Thank you so much, Chief Justice. Now to close this session, I would now like to cordially invite Pak Ota, CEO of Indonesia Ocean Justice Initiative, or IOJI, to deliver the closing remarks. Please, Pak Ota.
Maaf ibu-ibu, bapak-bapak. Sekali lagi terima kasih kepada Yang Mulia Chief Justice Ibu Debra Mortimer atas kehadirannya dan berbagi ilmu, berbagi pengalaman di hadapan kita semua. Dan Yang Mulia Pak Agung Sumanatha, terima kasih banyak, dan delegasi dari Australia, dan juga bapak-bapak, ibu-ibu panelis lainnya, kemudian pimpinan Sekolah Tinggi Hukum Jentera, dan semua yang hadir di sini. Hari ini adalah momentum yang sangat penting. Forum ini memberi kita kesempatan yang luar biasa untuk berkolaborasi, bertukar pikiran, bertukar pengalaman dalam mewujudkan keadilan ekologis, ecological justice, termasuk di dalamnya keadilan iklim, climate justice. Kita semua sedang hidup di tengah perubahan lingkungan yang belum pernah terjadi sebelumnya. Batas aman bagi kelangsungan hidup manusia di bumi kini berada dalam kondisi bahaya. Unsafe operating space for humanity and other living beings. Karena itu diskusi dan kerjasama yang kita lakukan di sini bukan sebatas diskursus akademis, melainkan membangun gerakan seluruh komponen bangsa untuk mencari solusi yang menyangkut masa depan bersama kita semua. Krisis iklim membawa dampak yang tidak merata. Masyarakat pesisir, masyarakat adat, perempuan, anak-anak, dan kelompok miskin merasakan beban yang lebih besar dibandingkan kelompok lain. Karena itu climate justice harus dipahami bukan hanya sebagai isu lingkungan hidup, tapi juga isu keadilan sosial, hak asasi manusia, dan masa depan generasi mendatang serta masa depan alam itu sendiri, intergenerational dan interspecies justices. Dalam menghadapi tantangan ini, peradilan memegang peran yang sangat besar. Tadi sudah disampaikan baik oleh panelis maupun para peserta yang hadir. Hakim memiliki tanggung jawab untuk memastikan bahwa hukum benar-benar mampu melindungi lingkungan dan menjamin hak hidup generasi mendatang. Peran tersebut tidak bisa berdiri sendiri. Masyarakat sipil juga, akademisi dan komunitas hukum termasuk Abgakum harus memberikan dukungan, baik melalui riset, advokasi, penguatan kapasitas, dan peran penyidikan, penuntutan yang berkualitas. Sehingga peradilan dapat mengambil keputusan yang bijak, berbasis sains, dan berpihak pada keadilan ekologis, in dubio pro natura. Kita menyaksikan bagaimana Mahkamah Konstitusi Republik Indonesia baru-baru ini melalui putusan nomor 35, tadi saya sudah menjelaskan, menolak permohonan perusahaan tambang yang ingin membuka usaha di pulau kecil. Dalam pertimbangannya, Mahkamah Konstitusi menafsirkan pasal 33 ayat 4 dengan paradigma pembangunan berkelanjutan beraliran kuat, strong sustainability. Apa artinya? Mahkamah Konstitusi menegaskan bahwa modal alam yang kritis atau kritikal tidak bisa disubstitusi, tidak bisa digantikan oleh kekayaan buatan manusia. Pulau-pulau kecil dan kawasan pesisir sebagai contoh critical natural capital tersebut. Mereka sangat rentan dan jika rusak tidak dapat dipulihkan kembali. Mahkamah Konstitusi juga mengaitkan hal ini dengan prinsip keadilan antar generasi dan intragenerasi, sehingga perlindungan lingkungan hidup tidak hanya untuk kita yang hidup saat ini, tapi juga untuk generasi mendatang. Putusan ini menjadi tonggak penting karena menunjukkan bagaimana hakim dalam hal ini adalah Majelis Hakim Mahkamah Konstitusi dapat melakukan judicial proactivism, judicial proactivism. Inilah bentuk konkret dari peran peradilan dalam menjawab triple planetary crisis, termasuk krisis iklim. Namun tantangan ke depan tentu tidak ringan. Tadi sudah dijelaskan sangat detail, sangat komprehensif oleh Pak Laude Syarif. Kita menyadari banyak perkara lingkungan hidup dan iklim yang kompleks, melibatkan bukti ilmiah yang rumit, prinsip-prinsip hukum internasional yang harus dipertimbangkan, terhadap komitmen nasional dan regional. Oleh karena itu, hakim tidak cukup hanya berpegang pada teks norma hukum semata, sudah disampaikan oleh Ibu Wiwi juga, diperlukan kemampuan analitikal yang tajam untuk menghubungkan hukum dengan sains, serta keberanian untuk menggunakan hukum sebagai instrumen perlindungan kehidupan melalui pendekatan judicial proactivism. Bapak Ibu yang saya hormati, kita juga perlu menyadari bahwa krisis iklim tidak bisa dihadapi hanya di ruang sidang pengadilan. Diperlukan pendidikan hukum, pendidikan sosial yang mampu membekali generasi muda, baik calon hakim, aparat penegak hukum, advokat, saintis, dan aktivis lingkungan hidup dengan pemahaman mendalam mengenai krisis iklim. Mereka harus memahami bagaimana hukum dapat menjadi bagian dari solusi. Dengan demikian, diharapkan lahir profesional muda yang climate literate, serta peka terhadap sains, masyarakat, dan keadilan. Di saat yang sama kita membutuhkan kerjasama lintas sektor. Forum ini sekali lagi salah satu contoh bagaimana kerjasama itu dibangun. Melalui dialog lintas negara Australia dengan Indonesia, kita belajar dari pengalaman Australia, dari tren global, dan dari praktek di Indonesia sendiri. Izinkan saya menutup dengan sebuah refleksi. Krisis iklim adalah krisis yang melampaui batas negara, batas sektor, bahkan batas generasi. Krisis bumi menguji seberapa serius kita mampu menegakkan hukum bukan hanya untuk generasi saat ini, tapi juga untuk generasi yang akan datang. Peradilan memiliki peran historis, yaitu untuk menegakkan hukum dengan visi keadilan yang lebih luas, berbasis HAM, berbasis sains, ekologi, dan berpihak pada keberlanjutan. In dubio pro natura, sekali lagi saya katakan, in dubio pro safe and just planetary. Karena itu, karena kita berdiskusi di dalam kampus Sekolah Tinggi Hukum Jentera, saya ingin menegaskan pendidikan hukum memiliki tanggung jawab moral, yaitu untuk menyiapkan generasi baru yang mampu mengartikulasikan hukum dalam menghadapi tantangan planet atau planetary challenges. Dengan semangat itu saya mengajak kita semua untuk terus memperkuat komitmen, memperluas kerjasama, dan memperkuat kapasitas agar peradilan dapat benar-benar menjadi benteng terakhir dalam mewujudkan keadilan ekologis atau ecological justice, termasuk keadilan iklim atau climate justice. Seperti kita diingatkan oleh Mary Robinson dalam bukunya Climate Justice, Hope, Resilience, and the Fight for Sustainable Future. All human beings are born free and equal in dignity and rights. Yet when it comes to the effects of climate change, there has been nothing but chronic injustice and the corrosion of human rights. Kutipan ini menegaskan bahwa krisis iklim bukan sekedar isu lingkungan, tapi juga persoalan keadilan dan kemanusiaan. Terima kasih atas perhatian Bapak Ibu sekalian, dan sekali lagi terima kasih kepada Jentera yang sudah memfasilitasi menjadi host dari acara ini. Assalamualaikum warahmatullahi wabarakatuh.
Thank you once again, Pak Ota, for your thoughtful closing remarks. And Bapak Ibu, that concludes the session of our public seminar today. Thank you all for your participation and attention. And I now hand it back to Master of Ceremony.
Thank you very much for everyone. And next, we will now proceed to the sovereign exchange. May I kindly invite Dr. Arya Suyudi to present the sovereigns to Justice Gusti Agung Sumanatha, Chief Justice Debra Mortimer, and Dr. Wiwi Awiati. Please step forward.
Goodie bag. More goodie bag.
Okay, thank you. And then may I also invite Mbak Aswin to present their sovereigns to Mr. Reynaldo G. Sembiring, Dr. Mas Achmad Santosa, and Dr. Laude M. Sharif. Please step forward. Okay, thank you everyone. After this seminar concludes, may I kindly invite everyone to the... Okay. Chief Justice Debra Mortimer.
I have two gifts. I want to give one to Justice Agung as our keynote speaker.
Okay.
One for the university, and it's, I think, fitting. It's a piece of Indigenous art from Australia. Thank you very much. And this is about the artist.
Okay, the description of the artist.
Yeah, and the story, because these paintings always have a story, so the artist tells the story in the legal attachment. I hope you find somewhere nice to put it.
I will put it. Thank you very much.
Thank you, Chief Justice Debra Mortimer. And after this seminar concludes, may I kindly invite everyone to the General Lounge for the second group photo sessions. Please, everyone to move General Lounge. Thank you very much and see you at our future programs. And this seminar can also be rewarded through the official YouTube channel of Jentera. Thank you everyone.